But I have one extreme urgent matter. I need leave. Move the same at tomorrow 10:30. Urgency is that matter. My capital shop license has been terminated without any show cause notice, without opportunity of hearing, without hearing, nothing. 8th order has been passed. It has been served upon me on 13th, 15th, 16th hours. Tomorrow 10:30. I'm paying leave.
You want the leave to move the matter tomorrow?
Tomorrow at 10:30.
Well, I'm mentioning what assigned matter. Item number 20. Matter is extremely urgent, my lord.
Item number?
20 of today's list. Assigned. Well, Kali fixed the matter any date specially fixed, subject to lawsuit convenience.
Today it can be taken up.
Today, my lord, in the list it has been written that group 8 matters will be taken up. No, my lord, Kali fixed the matter. I will inform that.
No, group 8 matter will be taken up. That is the group 8 is the determination.
Hey, this is a civil division.
I understand. Specially assigned matter I will take up after the group 8 matters.
Then my lord, Kali fixed the matter. I'm my harmly praying.
Today I can take up this matter.
No, today, my lord, I will inform the other. Any date subject to lawsuit convenience at 10:30. Very short matter, my lord.
No, 10:30 I cannot fix.
I'll any date subject next week, my lord, 25th.
Wednesday I have taken up this matter. Most of the assigned matter I have concluded.
Yes,
this matter.
This has not been touched, my lord. Subject.
This matter, petitioner, you are item number 20. It was called on the Wednesday.
I'm for the petitioner.
Wednesday, this matter was called. You are not there.
Oh, sorry about it. I missed the list.
Wednesday, I have taken up all the matters except 3 matters.
2 p.m. my lord.
Not 2 p.m. I cannot fix these matters. I have fixed matters already in 2 p.m. and 10:30. There are several matters. That's why I cannot fix the matters.
Next week, any day, Monday, my lord. Otherwise, I could not.
Why next week? Why not this week?
Any date, my lord.
Tomorrow, this matter can be taken up.
Tomorrow,
according to the list.
Then Wednesday, your lordship take it. I will inform the other side. Take it Wednesday. Wednesday at 2 p.m.
Today, new motion matter first. First to be mentioned. Yes, this matter can be taken up only after 5 minutes. This matter can be taken up. Today, it is in the list. I shall start the list from 14.
Not then can you make it not today?
Okay, very well. Not today.
Tomorrow, my lord. Tomorrow.
Tomorrow it will be in the list.
Tomorrow.
Yes.
My lord, may I permitted to mention one urgent matter? Today's is, my lord, item number 111, my lord. Group 8 motion, my lord.
Yes, new motion matter.
Last occasion, I had also mentioned this matter for upgradation. Your lordship asked me whether anyone already provisional approval granted to the authority RTA application, my lord, during pendency of this petition.
Just wait. No. Oh, what is your item? What is your item number?
111. I had mentioned earlier also, my lord.
What you want? Upgradation?
Upgradation, my lord.
Let me take up the matters first.
My lord, kindly fix any date, my lord.
Any date I cannot particularly fix. I will take up the new motion matter according to the list.
My lord, upgradation.
Today, entire day is there. Not necessary for upgradation. It may be reached today also.
Much obliged.
Yes. Just wait and see.
I mention as regard item number 196 of today's list, appearing as to be mentioned. There is some
to be mentioned. Mention matter. No, to be mentioned. To be mentioned matter will be taken up tomorrow first. Tomorrow it will be taken up first. Yes.
My lord, may I permit to mention one recalling application, my lord?
Recalling application? Have you filed it?
Yes, my lord, we have filed it, my lord. It's in connection with the criminal division that was your lordship had taken up in the while sitting in the vacation bench, my lord.
Now you have filed the recalling?
My lord, we had only got of knowledge, my lord. The client.
I have left the determination 2 years ago.
My lord, it was when your lordship had been sitting in the vacation bench this year, my lord.
Okay, this vacation bench.
This vacation bench.
So who are you?
But I'm for the wife, my lord. Opposite party wife.
You were there at the time of hearing?
No, my lord. Without service, without
serving. No service was there. Either I shall not take up any matter without serving. Without service,
I shall serve the other side, my lord.
No. In the vacation bench, I take up only the contested matters, not the.
In the order, it has been categorically recorded, my lord, that considering some urgency, my lord, the quantum of pension was reduced in favor of the husband, my lord. No, sir, notice was served, no application was served upon the opposite.
Show me the order.
Lord, the order, I can show it on,
Show me the order, not net. I want the order.
Lord, physical copy, my lord.
Come Wednesday. Come Wednesday with the physical copy. Yes,
Chief, if I may be permitted to mention a matter, it's item number 125 of today's list, Your Lordship.
125. I will take up this matter today
For non-prosecution, Your Lordship, kindly.
for non-prosecution.
Yes, Your Lordship.
125.
Yes, Your Lordship.
Do you have the instruction, written instruction of your client? Do you have your written instruction?
Yes, Your Lordship.
You have the written instruction of your client.
Yes, Your Lordship. My senior has.
I want the written instruction of the petitioner. Do you have it?
Right now, no, Your Lordship.
Then you come after instruction. Without written instruction, I shall not pass any order for non-prosecution.
Get one.
Group one, there are some urgency.
Group 1. Thursday.
Thursday, but kindly give some steps. To indicate this date for execution of the order passed by the certificate of, they will issue the warrant.
20th.
20th.
20th this week. So how can I fix this matter?
Thursday, you must can give some preference.
Thursday.
Kindly-
Thursday 21. Thursday, have you, whether it is listed, whether it is listed matter,
No, it's not listed.
then it give. Thursday to be mentioned.
Your Lordship, may I permit to mention item number 139 of today's list? This is the matter regarding the curtailment of customer, and the matter is covered by your Lordship's order. There are so many orders passed by your Lordship on previous.
Tomorrow to be mentioned. 139 tomorrow to be mentioned. Next,
My lord, item number 185, my lord. This is a review application out of your lordship's earlier jurisdiction, earlier date
85.
185, my lord.
Mention matter.
Mentioned matter, my lord.
Tomorrow I will take a mention matter first.
My lord, fast, my lord, so that my lord,
First
27.
matter. Tomorrow mention matter. They not.
My lord, say, my lord,
Few matters are there.
my lord, problem is that my lord, it has been running in the appearing before your lordship for quite some time, my lord. Since the fixed matters are eating away the
Fixed matter. There is no such fixed matter in 10:30.
tomato, there is no such.
No such fixed matter 10:30. I will take up this matter today.
Deep-
Today I am taking new motion matter. Tomorrow mention matter.
Deeply obliged, my lord, sir.
Okay, please call the list.
My lord, I am for the petitioner. It's appearing at my instance, my lord.
Yes.
These are that 4 sugar matters, my lord. If your lordship remembers, your lordship had
What
disposed.
section you want?
Yes. My lord, I am having a copy for your lordship's perusal. There are certain typographical errors. Whatever we could find, my lord, we have ascertained it. If your lordship just all typographical.
All metric tons, not tons.
Yes, that would change the entire
I understand.
gambit of this. And my lord, at the first page, if your
Very
lordship
much
sees,
also in difficulty. Somewhere you in
Okay.
your written argument it was ton, metric ton.
I
And somewhere it was tons.
our mistake.
I was just astonished what can be done. Yes. Metric tons.
Everywhere it's gone.
Please take down. This matter appears under the heading correction. In the order dated 24th of March 2025, there are some inadvertent typographical errors in the body of the judgment. Learned counsel for the petitioner has placed a copy of the has mentioned the typographical errors. Let the typographical errors appearing in the body of the judgment be corrected accordingly. Next page karo. In the cause title, the petitioner's name in WPA 3510 1981 and WPA 1357 of 1981 as well as WPA 4661 of 1984 should be correctly written as Vishnu Sugar Mills Limited and others. Full stop. Next para in WPA 13574 of 1981. The name of the respondent should be written as Union of India and others instead of Union of India and others. Vishnu Sugar Mills Limited and others instead of State of West Bengal. In the next, in the second page, paragraph 1, line 2, last word should be in instead of on. In paragraph 2, line 2, tons should be T-O-N-S. Tons, ton, C-O-N, T-O-N, S to the one. Ton should be read as metric tons. Paragraph 3, after second line, two words, that is within bracket, within inverted comma, which was, should be inserted. And in the C line, after consider inverted comma, now consider should be read as considered and turn should be read as turned. Read as turned. Page 3, at line 6, unit should be read as crossings, C-R-U-S-H-I-N-G. Line 6, C-R, should be unit is crossing, not unit capacity, crossing capacity. Crossing within inverted comma. Therefore, line take over 6 line, 7 line. In line 7, before tons, term metric, M-E-T-R-I-C, metric should be inserted. In 8th line, after term put it, in should be inserted. So to 8th line, 9, 10. Yeah. At line 11, last word permitted should be read as paid. In the last part, one line of the same paragraph, entertained should be read as entitled. In the same page, paragraph 5, line 2, before tons, T-O-N-S, metric, M-E-T-R-I-C, metric should be inserted. এটা ধীরে ধীরে দেখে এইভাবে করতে হবে, ঠিক আছে? যেরকম বলে দিলাম সব প্যারাগ্রাফ দিয়ে দেখে আমার তাহলে দেখি, ঠিক আছে? না লাস্টে করবে, লাস্টে লিখে নাও। The office is directed to make the above mentioned corrections in the body of the judgment within a fortnight. নাহলে পরে দেখে দেখে করবে, দেখে দেখে যেরকম করে বলেছি করে দেবে।
My lord,
Next,
the other ones in the
I'll correct now.
deeply.
Lordship, one indulgence before your lordship. So many late lordship, and 150 curtailment of vacancy lordship. Earlier also I mentioned before your lordship.
Item number,
150 lordship.
I will take up this matter today.
Today lordship 32 150 lordship 150.
Let's see, let's start the list first. Who is there?
19.
Hmm? কি বলো, কি হয়েছে বলো? হ্যাঁ কারেকশন কি হয়েছে, কিছু বলেছে কোথায় কারেকশন? হ্যাঁ এসএটি নাম্বার 539 of 2016, 539 of 2016 same. কোথায়? এটা কারেক্টেড উইথ লিভ গ্রান্টেড, কারেক্ট হয়েছে তো কি হয়েছে? বিজেন্দ্র প্রসাদ, ভবতোষ রয়, তা কেন হবে? ভবতোষ রয় আর বিজেন্দ্র প্রসাদটা কেটে গেছে। আচ্ছা ঠিক আছে। This matter appears for correction in the order dated in the cause title of order dated 7th of March 2025. The name of the respondent should be read as Salini Chaurasia and others instead of Vijendra Prasad and others. Next.
Lordship, I appear for the petitioner, my lord.
But I am for the state, my lord.
Lordship, in the order dated 17th of May, my lord, the case number has been written wrongly, my lord. It is supposed to be 1485 of 2025, my lord. It's written as 2024.
Order dated?
17th of May,
What is the order of
2025.
17th of May? Which matter you are referring? Item number 18,
18,
14815.
14815.
15th, last order is 15th of July.
15th of July, my lord. I apologize.
Yes, what is the number?
14815 of 2025, my lord.
2025.
Yes.
Okay, this matter appears for correction in the order dated 15/7/2025. The writ petition number should be correctly read as WPA 14815 of 2025 instead of 14815 of 2024. Next.
Obligation.
I appear for the respondent, Bharat Petroleum Corporation, my lord. The certain corrections, my lord. Indicate. Losses may kindly seize the first page, my page 4, para 9.
Page 4, para 9, Mr.
Para
Nath.
9. And
Yes.
only one oil marketing company is party, my lord. Only Bharat Petroleum, not the all oil marketing companies. The first line.
You are for only Bharat Petroleum.
And in this writ petition, only Bharat Petroleum is the only party.
As all matters at heart.
Yes.
In
Yes.
item in paragraph 9.
Yes.
Yes.
But in para 10 also, the oil marketing companies, it's also mentioned.
Para 10.
Yes.
It is BPCL.
It is only BPCL.
Yes.
And also, my lord, can you see para 10, the last line, a HP gas manual, it will be LP gas manual because the gas
LP,
LP because the gas manual that we have shown is LP gas manual.
LP gas.
Manual,
My
there
lord, is actually by all the three companies. HP is also there, so it's not
No, no.
wrong.
Mr. Nag has handed over this
This
LP
one,
gas man.
Yes, yes.
It
That
has
means
HP.
It was noted.
This is also HP. That's what I'm
No,
saying.
no,
No, no, no, no.
name.
This
Ah.
name, this name.
LP.
By
Only
all
I
three
take
companies.
the
Yes.
nomenclature only. No.
Yes, yes. The liquefied petroleum. LP is liquefied petroleum. Then, if you losses kindly sees page 6,
Page 6.
the third line from top. It is submitted that competition, the policy decision, I think, is not. I think it will be the policy decision will increase competition and only benefit. Otherwise, it does not
Yes, the
making.
competition should be omitted.
Yes,
Yeah.
yes.
It is submitted that the policy decision will benefit the service of the customers. Okay.
Competition can be deleted.
No,
No.
competition, the policy.
Ah.
Instead of that, it will increase competition. The policy decision will increase competition and only benefit.
Okay. Let it forget. Let's. Okay.
Now, another, my lord, that is very vital. Page 16. Because your losses were dictating orders in all the 4 matters. That's why in the first 3 matters, there was the cartelments, the letters were challenged.
Yes.
The letters by which the distributors were cartel. Those letters were challenged, and accordingly, losses has passed an interim order in respect of those letters. In this writ petition, your losses has not passed that order because that was not the subject matter. Para 29 won't be there. This para 29 is in respect of the other 3 writ petitions. Because at page 31, this is the interim order in this writ petition.
Okay.
Para
okay,
31.
okay.
There cannot be any further curtailment. That's what was the interim order.
Okay. Para G and H of those other.
Other 3, yes. But
Okay.
para 29 won't be there.
Should be omitted.
Yes.
Please take down. This.
My lord, I am opposing this. You know, G and H was very consciously given. It is not the case that it is not a case
No,
that
in your
My-
matter, G
in my
H is
matter
there.
also. Yes.
My lord,
Yes.
it was the lordships had dictated
And
the
it-
order in open court. Through the YouTube live streaming also, whether I heard wrongly or not. Your losses has not passed this order. This order was passed in respect the earlier 3 repetitions.
Because in my learned
My
senior
linelet fan
counsel,
can
Mr.
verify from the YouTube streaming
No,
as
no,
well.
that's fine.
And I
My
can't
lord,
say something which is
Mr. My learned senior counsel,
No,
Mr.
G-
Saharoy, when he
H
argued,
is otherwise. That
Yes.
is the earlier.
Yes, in those 2
in their
repetitions.
case,
No,
Mr.
no.
Saharoy's
No,
case,
no.
my lord,
Look.
there was a letter.
Prayer H, you look.
Yes.
That is in respect of earlier orders like that.
In my case, they did not even give me a letter.
That's
So
why there was
I-
no.
So, and
And
they
so-
transfer 1918
No, no.
customers.
H in respect of other 3 matters.
Yes, ma'am.
Yes.
Not this matters.
But in my case, there was no even intimation. So the
That is
proposed,
the merit. I
Correct,
have
correct,
already passed the order. There is an intent.
but my 1918
That's why-
customers in the system only got transferred,
That's why
but not.
para
but not-
31 years losses has given the interim order. Para 31.
Yes, there
But-
is interim order.
Yes, my lord,
But in respect of G and H,
I-
there are other pairs in the other writ petitions.
I bow down.
You
to what
understand?
Yes, I bow down. I have seen their prayers
Yes.
also. Mr. Saharoy had kind enough
But
to show.
you have in H, you
In-
have incorporated the earlier transfer of that. That
Yes.
is not the subject
Insofar
matter
as
in this.
4069 is concerned, I bow down that I am not even seeking that. I can take the concession. But insofar as 1918 customers are concerned, I stand in the same position as Mr. Saharoy. where
In
they
that
got
case,
a-
my learned
because
friend has
that
to
happened
file,
on 20th
come up
June.
with a
No, no,
modification
no,
application.
no,
because
no,
that
no,
was not
please-
the order.
Please
No,
see,
sir, I have already passed G and H in respect of other 3
Yes.
correct. Please see my eye. Please see my prayer eye.
But there can be a prayer, but that was not the order passed by your lordships. My learned friend can verify from the YouTube streaming as
My
well.
lord, 1918 customers when they got transferred in 20th May. Then I approached this honorable court. How did they get transferred? Only in the system, not even a letter or email. That was the trigger point for me to come before your lord. See, if that itself I am not protected, because
maybe,
as
but-
of now, only in the system it has gone. It is not that unless a customer books a LPG, then only the new distributor will.
There are interim order in favor of you.
Yes, my lord, that 1918 has to be protected. I'm not even questioning that 4069 in 2019 which happened.
Today, then my
I'm
learned friend has to
voluntarily saying that I'm not even seeking their return.
Circular
Yes, sir.
issued by COL marketing companies on 21st February is hereby stayed.
Correct.
That is the interim
And
order.
under
That is
that-
all purpose, all service,
Yes.
all everything stayed.
Yes. So 1918 customers who has been
Today I cannot pass that order. Today it is for correction only.
Yes, my lord.
Correct.
If he loses, if
So-
the learned friend wants a fresh interim order, there's come up a
Yes.
fresh
I'm
application.
fresh. I'm only saying that insofar as G, H, and I, you restrict it to the 1918 which they are proposing to transfer.
That was not the order passed.
Please see my writ petition.
I'm not saying
No, no,
it is
today
not
I
there
am
in the
not
writ
passing
petition.
any
That was
interim
not the
order.
order. What I'm saying, that was not the order that my lord has passed.
Yes.
I am only on the
Yes,
order
yes.
that my lord has
Okay,
passed.
understand. Anaspaj, please come, please come. First, you mention paragraph 7,
Para 9, my lord.
para 9. This matter appears for correction under the heading of correction, full stop, in order dated 24th of July 2025 at paragraph 9.
Para
Line
9
one.
and 10. Para 9 and 10.
Line, paragraph 9 and 10. Line 1. The oil marketing companies should be read as Hindustan Petroleum
No, no,
Corp-
my Bharat Petroleum
Bharat,
Corporation,
Bharat Petroleum
Corporation Limited.
Corporation Limited. কি বললাম বলো? Instead of oil marketing companies. 9, 10 and thereafter
Mana 9, 10, then 12,
12. At
12,
paragraph 12,
12, 13, 14.
the oil at paragraph 12, paragraph 12, line 2, the oil marketing companies should be read as BPCL. 12 thereafter
13, my lord.
13. 12 and 13. একই লিখবে 12 and 13.
And thereafter, my lord,
Oil
14.
marketing companies should be read as
EPCL.
BPCL. Thereafter
14, my lord.
14. Now, where you have shown that
Literally a review is happening.
HP gas manual,
Mana LP.
paragraph 12.
That is there at para 10, 10, 11 and 12.
Okay. In paragraph, next column. In paragraph 10, 11 and 12, the HP gas manual within inverted comma should be read as LP gas manual.
Yes, my lord.
Very good. Next,
But at para 13, that at page 6, that competition should not be there.
paragraph
Paragraph 13 at page 6. Fourth line from top.
in paragraph in paragraph 13, page 6. In the fourth line, first two words, the competition within inverted comma, the competition should be omitted. Now paragraph 29.
Yes, at page 16, my lord.
In page 16, paragraph 29,
Only the last sentence can go.
Well, this entire paragraph is in respect of the earlier opinion because similar paragraph is at page at para 30. Kindly see para 30 in considering.
yes, prima facie case. Paragraph 29 should be omitted. Consequently, full stop. Page 16, paragraph 29 should be omitted. Consequently, paragraph 30 and 31 should be numbered as 29 and 30 respectively. Remaining portion of the order should not be altered. Full stop. The office is directed to make necessary correction as mentioned here in above in the body of the order itself within a fortnight. Okay.
Great.
Macho.
Next, 21.
We appear for the petition. এটাকে সার্ভ করেছি?
Have you served?
I appear for
You
the
are
P number one.
Yes, my lord, we have served.
You are the caveator.
I am the caveat.
Yes.
But this was a suit filed by my client, the plaintiff, under section 6 of the Specific Relief Act. But what had happened? But an eviction suit was filed before the Small Causes Court, Calcutta. In the eviction suit, we got a contested decree. After the contested decree, execution was levied. They entered appearance in the execution proceedings. But again, a date was fixed for delivery of possession. On the date of delivery of possession, and prior to that also, they filed several applications that we have filed an appeal in the City Civil Court, but they did not get any order of stay. On the basis of that, we took possession. There was the bailiff report. On the basis of the bailiff report, certain articles were kept under my custody. I am the decree holder. That was kept because those were lying there and there was nobody to take it at that point of time. But subsequent to that, they came, took over the articles. After taking the articles, they made an endorsement in the copy of the bailiff report that was given to us. It is a list of the articles that are kept.
Inventories are there.
Absolutely. Malad, this happened. Thereafter, on a particular date, Malad, they again took possession of the suit property. But this has happened, so we filed the section 6 that we have been dispossessed after getting possession. Lordship knows, in a matter where their section 6 is involved, nobody can challenge the title of the parties and all these things. But what the trial court did, the trial court observed all this. But after considering the bailiff report, he disbelieved that. He said, the trial court said that in the bailiff report it appears the possession was taken by the decree holder. But how the articles were given back to him, the judgment debtor, this creates some infirmity. And accordingly, I am unable to rely upon the bailiff report. On the basis of that, my suit under section 6, that was dismissed. In the meantime, something more happened. That is, they had filed an appeal before the City Civil Court
Against the order?
against the original
Earlier order,
judgment and decree.
termination.
Lordship. The judgment and decree passed by the trial court, that was set aside.
Okay.
Against that, appeal is pending. But I understand this. But in a section 6 application, the only scope is to consider whether a party has been illegally dispossessed or not. If dispossessed, yes, whatever be the the title of the parties and all these cannot come under the purview of, adjudication before the trial court. But all these things have been ignored, and an order has and a judgment has been passed against which I cannot appeal. I had to prefer a revision before your lordship. But this is the crux of the matter. I want to elaborate this because all
So
the
one date has to be fixed. A long hearing is required.
but some time is required. Lordship, if lordship desires, the LCR can also be
Lordship,
called
fine.
for.
LCR of that matter, of this
Yes,
of that suit.
yes, that's true.
CO number 2206. No.
Title suit number 1631.
Title
That
suit-
would be required, my
So
lord.
that would be required.
Title suit number 1631 of
One of
2023.
Lordship.
Please take down.
But in the meantime, my lord, but they should not create any third party right in respect of the property because admittedly they are in possession.
Lord, I'm seriously objecting to this.
My lord, they are
How can you, third party interest you can be
how
created?
they can create third party interest.
Are
I
you
do
raising
not.
objection?
Lord, I'm raising objection.
Yes.
Lord, because Lord, the subject matter of the property which is concerned, Lord, this is a Thika property. I have been declared as a Thika tenant.
Very well. Appeal is pending.
Lord, the
Appeal is
in
pending
the
before
appeal
this
date.
court.
Appeal is pending before that court. Lord, they have preferred an application for injunction. Lord, that is pending.
Whatever may be,
Lord,
let it
can
be there.
application.
Let it be there. Let it be decided by the appellate court.
Lordship will kindly consider my prayer at page number 9 of the revisional application. Transferring, alienating, encumbering, letting out, changing the nature and character, or creating any third party interest. Now, this is essential. Page number 9.
Okay, please, only third party interest, not others.
That's
But letting out, my lord, that is essential.
Lord, letting out cannot be done because the trial court has specifically observed. Lord, there are some other persons also residing in the property. Lord,
Very
if your lordship
No, no.
held,
Okay, okay.
Lord, it would
Subletting
be a-
question is there already.
No, there is
Lord, there is there.
Lord,
Lord,
they
it has
are
been recorded in the judgment.
in
Lord, if this order is passed, they will come up with an application for contempt that we have violated the order. It will result in multiplicity of proceedings.
but kindly see the intent. But they are giving the property to third parties. Now they are saying that there are third parties. Malad, if I bring a contempt and everything, it would not be to my benefit, Malad. That would
Whatever may
unnecessarily
be, no further third party interest, if any.
no further
No
third
further
party.
third party.
No further.
And Malad, no further third party and changing the nature and character. But
What
they
is
might,
the, what is the building?
but it is a very small one-storied and partly two-storied building.
Lord, changing the nature and character of the suit property, Lord, this suit property is again a fishy thing. Lord, why I
Suit
say, Lord,
property?
Lord, the suit property which my learned friend is claiming, Lord, in this title suit, Lord, this is another a fishy point. Lord, in the degree it has been stated 300 square feet. Lord, the property which he is claiming in this title suit, Lord, is 940 square feet, which is apart from the degree. Lord, this must be
If
decided.
you want the section 6 application is there.
Lord, section
Delivery
6.
of possession, whatever may be the suit property otherwise. Section 6 is there.
But admittedly, they have
They are
taken
dealing with
possession.
Section 6 of Specification Act, that is the title suit.
Yes.
Only this matter would be there.
That's-
Only this matter can be protected, nothing more than that. The instant civil revision is directed against judgment and order dated 21st of May 2025, passed by learned judge, 11th bench, City Civil Court at Calcutta, in title suit number 1631 of 2023. The petitioner is the plaintiff before the learned City Civil Court concerned, whose suit filed under section 6 of Specification Act was dismissed. Full stop. Having heard the learned counsel for the parties, also considering the matter that the respondent has, opposite party has already been appeared, and the instant civil revision requires to be heard at length. Accordingly, let the matter appear in the list on
But kindly makes it 2 p.m. Malad for convenience of
that's
the
why I am on
Lordship. I'm grateful.
8th of September. দেখা যাচ্ছে না? 9th of September 2000. 9th of September 2025, special fixed at 2 p.m.
Informal
Full
deal.
stop. Next, having heard the learned counsel for the parties and also considering the prayer made in the instant civil revision, there shall be an order of status quo in respect of nature and character of the suit property and the suit property till a period of 8 weeks from date. not 8 weeks.
মানে any possession, my lord.
Admittedly, they are in possession.
I am in position.
Yes, মানে they should not give it
If
to
I
third-
protect them, I will also protect them.
Yes,
Okay, okay, okay.
status
nature,
quo as
character and
regards
possession.
possession.
Nature, state. কি বললাম বলো আগে বলো। There is an order of status quo in respect of nature, character, and possession in respect of the suit property till a period of 8 weeks from date, and the opposite parties are directed not to create any not to create any further third party interest over the suit property till further order. Full stop. No,
That has to
let
call for the
okay.
lower court records.
The office is directed to call for the trial court record of title suit number 1631 of 2023, pending with 1631 of 2023 from the court of learned
11th judge.
11 City Civil Court, 11th bench, Kolkata. Learned Court of City Civil, Learned City Civil Court, 11th bench, Judge, 11th bench, Kolkata. From the court of Learned Judge, 11th bench, City Civil Court at Calcutta. Next,
I have to pay the special messenger cost, my lord.
you want to pay the special messenger? That is very near. Is it?
But still,
Okay, still.
এটা লিখে নিতে হবে।
The office is directed to bring the record, bring the trial court record through a special messenger, cost to be borne by the petitioner, who shall deposit the special messenger cost
Within this week.
within this week.
Your lordships can fix 10th instead of 9 or 8.
I have fixed it on
আরে পরে অনেক
9th. You want 10th?
Not 10.
10th 2 p.m. 10th 2 p.m. Next,
grateful.
22 Your Lordship, I'm praying for not today, Your Lordship, Mr.
okay, very well, not today.
Good.
Next,
This is the case. Interim order has been already been expired. If you want to kindly take up the application filed by us.
can one.
Can one. But kindly turn to page 6, the first order passed by this court. Justice Portonayo. তুমি আছো তো?
24.
না, এটা কত? এটা কোন তো? 2, 3. But page 6 is the order with operative portion, page 8, last but one paragraph. Accordingly, this interim order has been extended by your lordship, page 9, till 30th August 2024.
Yes.
Thereafter, no extension has been paid for. This is the fault of mine.
What is the status of this case?
Then license has been granted, allotment has not yet been made, card has not been tagged. So if your lordship pass order of status quo, that will survive my.
Have you served this
Yes,
application?
my letter is appeared. Yeah, Chana? Oh, sorry. Yes, I have served. Notice has been given, copy has been served. But that- এটা? Can. Notice has also been given. Ashim Kumar Ganguly is the state representing the state.
Validity of control order 2013. Same issue.
Same.
Please take down. Can one of 2024. Can one of 2024. When you filed the application? 24. 13th of November.
My lord. Thereafter, matter is appearing long back, since long back.
Hmm. Can 1 of 2024? This is an application for interim order, which was for interim order, which was passed by this court on 12th of December 2013, 2023, and thereafter extended till 30th of August 2024. Mr. Sahara, learned senior counsel, appearing on behalf of the petitioner, submits that interim order was passed by this court, which was extended till 30th of August 2024. Thereafter, the interim order was not extended. Thus, the instant application is filed for reimposition stroke reinstate the interim order passed by this court dated 12th of December 2023. Or the learned counsel. Full stop. It appears that the copy of an application was served upon the learned counsel appearing on behalf of the state. In spite of service, full stop. In spite of service, none appears on behalf of the state respondent. Next, it appears that in the instant writ petition, the validity of control order 2000 validity of West Bengal Public Distribution System Maintenance and Control Order 2013, which is under challenge. Full stop. The coordinate bench of this court, in deciding the issue in motion stage, has observed that an appeal is pending before the Honorable Division Bench. In respect of the self-same issue, thus the bench has passed the interim order. Full stop. Next, it appears that the issue involved in the instant writ petition is pending before the Honorable Division Bench in MAT 1543 of 2024, wherein the Honorable Division Bench has passed an interim order on 8th of August 2024. Considering the entire circumstances, it appears to be necessary to reinstate the interim order passed by this court on 12th of December 2023. On 12th of December, 12th of December 2024. Under the above observation, the instant application being Can 1 of 2024 is considered and allowed. Full stop. The interim order passed by this court on 12th of December 2023 and further extended by this court till 30th of August 2024 is further reinstated, and the interim order should be valid till 24th of September 2025 or until further order, whichever is applicable. Can 1 dispose of?
But they have filed a report. I am filing the exception. You'll also can record it. Copy served.
Whether they have filed the report?
Copy served.
No report.
So we can keep it, my lord.
Let them file it.
They have served us.
Call the list.
The application for restoration, your lordship, matter was
কে বলেছিল? তোমাকে হ্যাঁ তাই তো বলি। স্যার আছে হ্যাঁ এটা করেছি।
Which for the state?
ঠিক আমি আপনার ডাউ আপনার ফার্স্ট স্টেটমেন্ট
on 29th of January 2025, 2020.
But this writ petition and my lord, the application itself is not in vogue, my lord. This is not maintainable.
This is a restoration application, your lordship, dismissed for default was made on 29th of January 2025. Passed by your lordship.
Yes, what is the matter? Well, first license has been granted on 1st August 2025,
Your lordship,
when there was no order of stay.
RI has been engaged for the same matter.
Now, who are you?
I am for the petitioner, my lord.
No, I understand
The
you are for the
application
petitioner.
CAN
What?
2 has been filed.
No, you filed the writ petition. Who are you? You are one of the applicant.
Yes, ma'am. Restoration.
What is the status? Already license granted? License granted. This is my lord, the
But
report. What was your challenge in the writ petition?
your lordship kindly
This is the report, my lord.
come to the prayer at page 14 of the writ petition.
Yes. You proceed.
I am led by Mr. Shah.
Why you, not you?
Your lordship, regarding the main matter, I am not ready today. But regarding CAN 2, this the
You must be
restoration.
ready. What is the
Your
matter?
lordship, kindly make it not today, then I can move this matter tomorrow. But prayer is at page 14 and 15.
No. You are not the applicant. You are one of the licensee, I think. Come on tomorrow then.
Yes.
May it be taken on Thursday, my lord. Mr. Ashwin Ganguly is ill. Thursday, I am taking group 1 matters. That is the difficulty. Day after tomorrow? Wednesday? Day after tomorrow, yes. You take your report all along with you. I report day after tomorrow. Next.
Your lordship, I appear on behalf of the state, your lordship, in this matter.
Application for addition of
There was a direction to file a report, your lordship. May a week's time may be granted to file the report.
this is my application for addition of party in the pending writ petition.
Serve করেছো?
Pursuant to the
Report in respect of the writ petition.
This is an application for
this is the application for addition of
party by Mr. Dhara. And I am for the writ petition, my lord. He is not getting the license because of the order of this honorable court. So therefore, my lord, I do not know whether
Can
1, my lord.
CAN 1.
CAN 2, my lord.
there are 2 cans. Why?
1 for addition of party, 1 for vacating of interim.
Can 2 is for addition of party. Very good. Who are you?
Pursuant to the, my lord, vacancy notice, I have been selected.
You
Because
have
of
been selected, but license was not granted.
not that.
And-
इसका पास ये का चाहिए.
Mr. Agarwal is one of the applicant.
My lord, I am the petitioner, my lord, I am the applicant.
One of the applicant.
No,
No, my lord.
my lord. This is challenging the vacancy of 2013 control order.
Okay. No, who are you? You are one of the applicant or not? You
No,
must-
I am the existing dealer.
Okay, you are the existing dealer. Yes. What is your objection?
Your lordship, I don't have any objection. Your lordship, there was a direction to file a report. I only seek to file the report in the course of this week to the main writ petition.
Yes, Mr. Agarwal.
I have no objection. Let it.
Let the applications be heard out together.
Can 2 of 2025. This is an application for addition of parties. Mr. Dhara, learned counsel appearing on behalf of the intending
জিজ্ঞেস করে তোমাকে দিতে দিয়ে না তোমার ফিটা হবে না.
What is your name? Sadhon Roy Mahanto.
Yes, ma'am. সাধারণ আর
Sadhana Roy Mahanto. বলো intending intervener, namely Sadhana Roy Mohanto, submits that in terms of the notification, impugn notification, the intending intervener was selected by the government authority for giving license. However, the license was not given yet, reasons best known to the respondent authority. He submits that as the vacancy notification is under challenge in this writ petition, the petitioner has a right to participate in the hearing. Full stop. Learned counsel appearing on behalf of the state submits that he has no objection if the application being can 2 of 2025 be allowed. Full stop. Mr. Agarwal, next paragraph. Learned counsel appearing on behalf of the petitioner submits that he has no objection. Considering the submission, he has no objection if the application for addition of parties be allowed. Having heard the learned counsel for the parties, also considering the body of application being can 2 of 2025, it appears that the present petitioner has submitted, the present intending intervener has submitted that he has been selected in terms of the impugned vacancy notification by the respondent authority. The annexure B shows the status of the vacancy, wherein the name of the intending intervener has noted as approved. Considering the situation, it appears that the instant writ petition cannot be disposed of without hearing the present intending intervener. Accordingly, the application being can 2 of 2025 is considered and allowed. The prayer for addition of parties made by intending intervener is allowed. Full stop. Petitioner is directed to make the intending intervener, namely, as a party respondent number 5 of the instant writ petition. The advocate on record of the writ petition, is directed to serve a copy of the writ petition upon the intending intervener and make necessary correction in the cause title of the writ petition within a fortnight.
My lord, let it be recorded that I have served a copy here.
Okay. Mr. Agarwal submits that he has already served a copy of the writ petition. Right here.
Copy petition.
Next paragraph. No, accordingly, can 2 of 2025 is disposed of. Next paragraph. An accommodation is sought for on behalf of the state for extension of time to submit a report. Considering the same, the time for filing report be extended for further 10 days. The matter shall appear in the list on.
My lord, let that is go out of list, my lord.
Okay. Let the matter go out of the list. Parties are liberty to mention after exchange of affidavits.
My lord.
Next. Affidavit service in respect of can 2 of 2025 is taken on record.
2 and 1 both, man.
2 and 1 both. Yes, next.
In this matter, my lord, my learned friend has filed an application for vacating the interim order. But vacating cannot be heard, my lord, until the main writ petition is heard. Because this is
Which
challenge.
matter? Can 1.
No, my lord, this one. Yes, can 1.
Next matter.
Next matter, my lord. That,
Application vacating interim order.
my lord.
Can 1, man.
This is 2013 control order, my lord. Therefore, it should be heard along with the writ petition.
And only direction is there, man.
Direction for filing affidavit is there, but I believe it is not required. It shall be heard along with the writ petition.
This is an application can 1 of 2025. This is an application for vacating interim order passed by this court on 18th of September 2024. It appears that the validity of WBPDS MNC control MNC order 2013 is under challenge in the instant writ petition. Issue full stop. Issue involved in the writ petition is pending before the Honorable Division Bench, being MAT 1543 of 2024. Considering the situation, it appears to me that the interim order passed by this court, cannot be considered separately to that of the writ petition. Let the interim order, let the application being CAN 1 of 2025 be heard. No. Let take it down. Accordingly, it is ordered that the CAN 1 of 2025 shall be heard along with the writ petition. Full stop. Let the matter go out of the list. Parties are elevated minutes.
Deeply obliged.
Next.
My lord, in this case, my lord, I am for the applicants, two applicants.
They should
My lord,
report,
I
maybe.
file application addition of party, and my lord, one application for my lord vacating of the interim order passed by your lordship.
Who are you?
My lord, আমাকে বলতে দাও, আমি বলি না, আমি তো applicant.
যে পিটিশনার হয়েছে আসেনি এর জন্য
না, এর জন্য আমি কি, আমি ভুগছি অনেকদিন ধরে, I am suffering for last 1 year. Lordship, I am the success, my lord, the present two applicants got the license through my lord due process of law from the state of West Bengal. Pursuant to the order of the pendency of the one, my lord, my lord, mandamus appeal, my lord, interim order passed by your lordship. Lordship, but the said, if your lordship kindly have a look into the division bench order that specifically stated in the said order only relates to dealer who are filed appeal, not for all dealer. My lord, that was, my lord, my only submission before your lordship. And we are suffering for last 1 year after getting the license from the government of West Bengal. And the state of West Bengal also filed report. That report, it revealed from that report that the Mrityunjay Chakraborty, present petitioner, never challenged the virus of the said notification first, and secondly, said Mrityunjay Chakraborty did not file any, my lord, intra-court appeal before the division bench. Kindly have a look into the division bench order, my lord. Your lordship, thousands time, my lord, this division bench order already seen. In spite of that, I am, for my satisfaction, lordship, kindly have a
What
look.
you want
My
to
lord,
make the addition of parties.
first addition of party, and then my lord vacating of the interim order, so that not for all, my lord.
No, I will take up one after another application. So what is the application? What are the applications for addition of parties?
My lord, can one, my lord, addition of party, Don Raha, my lord, applicant, he want to add as a, my lord, respondent in the instant writ petition filed by Mrityunjay Chakraborty.
And can 4 is the
can 3 also addition of party.
Can 3 is the vacating or interim order.
Lordship, no, my lord, can 3 addition of party for renew only. Can 3 and can 4 and 2, my lord, vacating the interim order filed by 2 applicants.
Yes, Mr. Dhada.
My lord, I am not.
What is your objection?
No, my lord, I am not appear in this matter.
You are not?
I am not appear in this matter. Mr. Mukumi Choudhury.
Okay, you are not there in the.
He is seeking for not to do on it. Last of it, I have been informed. Your lordship directed to file the opposition to the application. He is affirmed the opposition, but today he could not come to the court. Tell him he will not be there.
Okay.
My lord, kindly clarify. I am not.
Come tomorrow then.
Tomorrow.
I will first hear addition of parties application, thereafter vacating order. And it would be better.
They should
And
report
take
maybe.
note that Can 1 is a application for addition of parties by Don Raha. Can 2 is an application for vacating interim order by Don Raha. Can 4 is an application for addition of parties by Rini Mollik. And can 3 is the application for vacating interim order by Rini Mollik.
My lord, probably, my lord.
Yes,
Can 1, my lord, application for addition of party filed by Don Raha? Can 1?
সেটাই বললো যাচ্ছে।
No, no,
I understand. What is the can 4? In
Can
your
4, my lord, application for vacating of the interim order?
no, can 4 is the addition of parties by Mollik. There is certain other number.
That is in the one.
Yes, numbering.
Sorry,
is there. Okay, you have you have filed the report.
Yes, yes.
Already
I
filed.
filed, already filed.
Have you received it?
My lord.
Do you want to
No,
anything?
my lord. The state
They are supporting you.
My lord.
Very good. Report in the form of affidavit filed on behalf of the respondent number 1 to 4 in respect of in respect of entire writ petition.
Writ petition.
Okay, report in the form of affidavit filed on behalf of the respondent number 1 to 4 be taken on record. Full stop. Let the matter appear tomorrow.
My lord. Get fully.
Or another same heading.
My lord,
Yes.
my lord, instead of tomorrow, day after tomorrow, my lord. Tomorrow one matter fixed 7:59.
Very well. Day after tomorrow.
My lord. Get fully.
Next.
28, my lord, I am for the applicant, my lord. My additional party application was allowed, but the writ petition was supposed to file their affidavit in opposition, my lord. Their prayer for filing, my lord, the affidavit in opposition was extended on 17th
By a
June, my
B
lord.
for the petition, my lord, this is my affidavit in opposition.
My lord, may I get a copy of the?
Sure, my lord, I will.
No, why it is appearing under the heading to application?
But there are two application for additional party that was allowed by my lord, and additional application for
Vacating.
Vacating.
This is the affidavit in opposition by the petition
Petitioner.
Yes, ma'am.
against the application for vacating.
Yes, ma'am.
Yes, ma'am.
Your lordship, Lord, passed an order relying upon the order of the division bench in
Chetarapet.
and Lord, pursuant to your lordship's order, Lord, the state was unaware of your lordship's order. After your lordship's order, the license was after your lordship's order was communicated upon the authority, Lord, authority was pleased to revoke the license. Lord, in vacating application, that revocation and your lordship's order is under challenge.
Okay. I understand. Yes. So today, are you ready today?
No, my lord, just I have received the affidavit in opposition. May it be taken up on Friday or
Affidavit in opposition file on behalf of the petitioner be taken on record. Let the matter appear in the next week under the same heading for hearing the application. Next.
Get.
In item number 29, lordship, I beg to appear on behalf of the petitioner.
Lordship, 29, I filed an application for addition of party. Number the fire price shop against which the adventure was published and which was challenged before your lordship. The challenge was 11.5 of the control order of 2024, the age restriction.
Age restriction.
Number I participated in the selection process. Number I went up to the final stage, but could not be given since due to the pendency of the writ petition, and you will also pass an interim order directing that the state can proceed but cannot give it any license to any person.
Whether you are selected?
Number that has not been declared, but I should not say any wrong submission for your lordship.
So
But the thing is that I have appeared, and my information is that I have selected, but it was not disclosed since this writ petition is pending for your lordship. And that's why I came up with an application for addition of party.
So virus of the act is under challenge.
Yes, my lord.
So how you are aggrieved?
Number, if kindly consider lordship that I am agreed by the interim order passed by your lordship. By an interim order, if your lordship kindly see your lordship's interim order once. May I read for your lordship? That's just operating portion. Respondent authorities are liberty to proceed with the selection process, but so far as the grant of the license to any individual applicant is concerned, same shall not be issued till the final decision of this matter.
Yes.
But this writ petition is pending. Number, due to the pendency of the writ petition,
Whether you are selected?
but I have told I am selected, but they have not disclosed anything since the writ petition is
Very
pending.
well, then,
But during such time, what happened, my lord, one of the writ petition, the first writ petition which was interim order passed by your lordship, that is in Sudip Sarkar case. This writ petition state take up into the appeal. But your lordship knows that the appeal court has pleased to modify the
Yes.
interim order and directed that writ petition can be yes, your lordship,
Or-
that subject to final result of the writ
Yes.
petition. Since the writ petition is pending, I have been selected. I'm told there is no such declaration to that effect. So if this order is coming into the way,
Your selection is not debarred by this order. You may be selected, but the only granting of license is debarred.
yes, yes,
That is the authority.
yes.
Whether you have been selected, that is the
That
only
state
question.
can
If-
say before your lordship.
Then you have the right.
That was not my question. In
That state can say.
I am the writ
And,
petitioner, lordship.
I have no instruction at all if I have selected or not.
This matter was
May I come
come
with
up
instruction?
under the heading of
And-
application.
Regarding the modification is concerned, my lord's order was modified to the extent and my lord was giving liberty to the petitioners. The license was granted in the pendency of the writ petition, my lord. For this, we are not giving any effect as these orders.
The several
No.
writ petition has
You
been
have,
tagged
you
and
have,
the lordship will
you are
constantly
directed
let
to
us-
proceed to select a person, but not to grant a license.
Yes, your lordship.
What is this?
What is the status? What is the status? I want to know.
The present
Whether
state, my
the
lord, I will
petitioner
come.
was selected,
Lordship, I will get
you
the
take
instruction.
instruction. Very well. Please take down. Can 1 of 2025. This is an application for addition of parties.
So my lord,
Impending intervener submits that the that he participated in the impugned selection proceeding, and she has been told, she has been told that she was selected. But this court has passed an interim order, thereby directed the respondent authority to proceed with the selection process, but so far as grant of license is concerned, the same shall not be issued till final decision of the matter. It is the further contention of the intending intervener that she has been she is the most suitable candidate and has been selected by the authority, but the decision was not intimated to the applicant. Considering the situation, to understand whether the petitioner is a necessary party or proper party in the instant writ petition, the state authority has to file a report regarding the status of the impugned vacancy notification. Let the report be filed within a week.
My lord.
List the matter.
Next Tuesday, my lord.
On 26th of August 2025 under the same heading.
Grateful, my lord.
but so far the order is concerned, lordship, he has not been added as a party till after the considering of the report, lordship. We will pass.
Yes, that is the order.
Yes, your lordship. Grateful to your lordship.
Next.
Lordship, I am on behalf of the petitioner.
Yes.
Praying for not today only because Mr. Dhar is engaged in courtroom number 11. There is a direction to file exception to the
report in the form of affidavit on behalf of prisoner 1 to 3 is there.
Yes, we have filed already.
You have filed the report.
Yes, exception to the report.
Let it appear under the heading hearing. Why is the new motion matter? Yes, very well. Please take down report to the exception to the report filed by the respondent number 1 to 3 be taken on record. It appears that the pleadings have completed. Let the matter appear in the list under the heading hearing on 25th of August 2025. Next.
Yes, my lord. In this matter, I am appearing on behalf of the petition.
My lord, these matters, lordship was pleased to last occasion, my lord was pleased to grant liberty to file an opposition. So kindly gives a 2 or 3 days extension, my lord, I am praying for, because we sent this matter before the department
That will be waited regarding the ensuing vacations, my lord. We are not able to approve these matters, my lord. Kindly keep 2 or 3 days extension, my lord. In the meantime, I file my report, my lord.
Give the last chance, my lord.
The report
Lordship.
next Monday.
This week, my lord, I will give in the copy of the other sides, my lord.
Mr. Amridullah Chatterjee, learned counsel appearing on behalf of the state respondent submits that state respondent
At 10:30, my lord.
seeks for an accommodation for extension of time to file the report, to file report as directed by this court on the earlier page. Considering the submission, the state respondent is directed to submit the report within a week positively. Let the matter appear in the list on 25th of August under the same heading.
As it especially fixed matter, my lord, as 10:30, my lord.
This is hearing matter.
No, my lord, kindly you lordship fix the matter on 10:30. I have some problem.
Why 10:30? No 10:30 business.
Grateful, my lord.
At the heading hearing.
I have seen number of matter fixed.
Let them. There are some.
In the meantime, my lord,
Then you lordship give me
advance copy
opportunity
will
to file
served
the
out in the
affidavit in reply against the.
Your matter is appearing in the list first. So why you want?
You are a PV.
No, my
Fix the matter. I will fix the matter for
all right, my lord. 25th.
particular date 2 p.m.
All right, my lord.
Do you want it?
Yes, my lord. 2
Very
p.m.
well. Let the matter it appear. No.
In the meantime, I shall file the give the opportunity to
Appears
file the
the-
affidavit in reply against the
Next করা
exception.
হবে না। Next ওই 18th হবে না ওটা কেটে দাও 18th হবে না কেটে দাও হবে না It appears that readings have already been completed. Let the matter appear in the list on 15th of September 2025 at 2 p.m.
Grateful, my lord.
as a special fixed matter.
In the
Parties
meantime,
are
my lord, I
directed to
served the
exchange
copy
their
of the
affidavit in
advance
the
copy.
meantime.
In the meantime, I shall file the
Parties
affidavit.
are directed to exchange their affidavit in the
Grateful,
meantime.
my lord. Grateful, my lord.
Next.
Grateful. I'm grateful.
I am for the petitioner.
I am for the private respondent number 6, madam.
I am for the petitioner, my lord. State respondent has filed a report. I need time to file an exception to the report.
Have you received the report?
I have received
But
the
kindly,
report.
kindly, my learned friend took number of times to file the report. It is fourth time, my lord. They have taken the time for filing report.
Status report
Kindly
is
see.
there. Only this.
Yes.
Not report in the form of affidavit.
There is form of affidavit.
Yes.
In the form of affidavit.
Affidavit is there.
Well, I have been selected. Private respondent has been selected on merit.
Yes, if you selected, you have given. Let the writ petition be disposed of.
Yes, madam. So my learned friend
That is
took
the
time.
report.
Yes, state has submitted the report.
He has submitted a copy of the report, not the report in form.
Not the report in the form of affidavit.
Report. I am saying
Yes,
report.
report.
Only they have submitted a file a report.
Yes.
They have already filed a report.
Yes, yes.
Not in the form
No,
of.
not in the form of
Okay, okay. You want to use
I have to
the
file the exception. Since there is allegation, there are some allegation against. There are some.
But
then come on 8th, 9th September.
I had a talk with the client also yesterday only.
Mr. Pingol Bhattacharjee, learned counsel appearing on behalf of the petitioner, intends to use exception against the report filed by the state. It appears that matter is otherwise ready for hearing. Let the matter appear in the list on 10th of June 10th of September 2025 at 2 p.m. for hearing of parties are at liberty to exchange their affidavits in the meantime. Next.
For the petitioner. 33, my lord, I am appearing for the private respondent number 8, my lord. Now, my lord, the state has taken out an exception. They have filed a supplementary affidavit, my lord. I have not received any of such copies, my lord.
You have not received?
No, not at all, my lord. My lord,
For
kindly.
last occasions, my learned friend was not appeared.
I have appeared on the last occasion, my lord.
Then why not receive?
I don't know what was my.
You are the private respondent.
I am the private respondent, my lord. My advocate on record has not received any neither the supplementary affidavit nor the exception filed by the state, my lord. Exception to the writ petition, my lord.
State to file a report in the form of affidavit in terms of supplementary affidavit.
No, my lord.
No.
Against the writ petition.
Against the writ petition also.
As well as the supplementary affidavit.
supplementary.
So where is that? Have you received the report?
Lordship, we have received a report, but
But
the
where is the
state
state?
state
But
has
I
to-
have not received a report.
Not filed the report.
state has to place the report before your lordship, sir. Until and unless that report is placed before your lordship, I cannot file the exceptions also.
Yes. However, you have received the copy of the report.
Lordship.
Have you received the supplementary?
No.
Supplementary affidavit?
In course of tomorrow, lordship, I'll hand it over.
Learned counsel appearing on behalf of the private respondent submits that he has not received the copy of supplementary affidavit filed by the petitioner. Petitioner is directed to serve the copy of supplementary affidavit upon the private respondent within this week. Full stop. It is submitted by the learned counsel for the petitioner that a copy of report has already been served. Copy of report of state has already been served upon the petitioner. None appears on behalf of the state authority. Full stop. No report has placed. Considering the situation, let the matter appear in the list under the same heading on 25. Parties are directed to exchange their affidavit in the meantime.
My lord, if my lord is directing to file me an opposition to their supplementary affidavit, then my lord, let it be in the
The opposition against the writ petition?
No, nothing at all, my lord. That's why I'm saying, my lord, if possible, my lord, then keep it in sometimes in the month of September, my lord, because my client resides in Malda, my lord, it will take some time for him to come.
Lordship, kindly take this matter on Monday after.
Yes.
finding the
Let
report.
this
Very well,
do the everything thereafter.
Very
I will take up this matter on 25 under the same heading.
Very good. Much obliged, Lord.
Grateful.
Next.
Your Lordship, I appear on behalf of the state.
I appear for the private respondent.
Yes.
Petition for your lordship is an applicant in respect of a vacancy. So far the petition is concerned, petition has been granted highest mark in the inquiry. Whereas surprisingly, petition has been given lesser marks in the interview. Thereafter, private respondent has been selected. I have a specific allegation that is so far private respondent is concerned, his swap-cum go-down is not, he cannot be declared as eligible since his swap-cum go-down is not meeting the specification mentioned in the vacancy declaration notice. There is no shade in front of his shop. Let us kindly come to page 21, first vacancy declaration notice. With the aiming and the shop cum go-down was constructed without any sanction plan. And reply of the Subdivision Control is very strange. There is no necessity of sanction plan. So kindly come to page 21 is the vacancy declaration notice.
Yes.
Next, your lordship, kindly come to the my application page 25. Is the receipt.
Yes.
Your lordship, kindly come to page 27. Reply by the Subdivision Control. In response to my
complaint.
Representations. Column 2, sanction plan of the construction go down. Kindly note the submission of the sanction plan for construction go down is not mandatory requirement. Next, structural specification as per clause 8C 8E of part 2 of the vacancy notification, clean level of the proposed scrap price shop is required to be at minimum 0.1 feet. Accordingly, additionally, the provision of veranda with adequate shade to accommodate at least 5 individuals in queue has been desired as desirable features. My specific allocation without sanction plan print height is below that, and there is no shade. This is a desirable one. Now you will also kindly come to page 35.
Yes.
35 your lordship will get the better copy. It's not readable. At the top, the private respondent has been granted 51. Have you lordship got it, my lord?
Yes.
And I have been granted 62. Highest mark, admittedly. So far, Vivabosi, he has been granted 20. I am given 4. And let the state file a report annexing the inquiry report of both the petitioner and the respondent, private respondent.
What is the status?
Status, my instruction is
The
that
license has been issued.
You are the private respondent. You are running the business. Okay.
the scope of interim order today.
No sort
There
of.
is scope of interim. So let them file the
Your Lordship, we shall file an opposition
report in the
dealing
form of
with all
affidavit.
the allegations as well as disclosing the inquiry report, Your Lordship. This is a specific instruction. On instruction, I submit that the petitioner was recorded as eligible on the condition, on one condition, because first of all, they did not fulfill a criteria, which is, Your Lordship, an NOC for the landowners is required to be submitted before the authorities at the time of application. Your Lordship, which has to be affirmed before the magistrate. Your Lordship, that mandatory provision was not complied with by the petitioner. Your Lordship, that is one of the criteria for granting him lesser marks, Your Lordship. Your Lordship, we shall come up with all the details and
Okay. Please take down. Petitioner applied for license in terms of vacancy notification dated 5th of June 2024 issued by the SCFS Ranaghat. It is the contention of the petitioner that he is the most suitable candidate to have the license. He got the highest mark in inquiry conducted by the officials of concerned SCFS. But instead of giving lesser mark to the private respondent in the inquiry report, the concerned district level fair price of selection committee has granted huge mark to the private respondent, thereby selected the private respondent as a suitable candidate, only to defeat the claim of the petitioner. He submits that the act and action of the respondent authority is purposive and malafide. Learned counsel appearing on behalf of the state submits that there are true justification to select the private respondent as a most suitable candidate, full stop. Though the petitioner has granted highest mark in the inquiry report, but he has failed to but there are reasons to give less mark by the concerned DLFPSC, district level fair price of selection committee. On that score, the state intends to use affidavit. Learned counsel appearing on behalf of the private respondent submits that he has already been granted the license and he is now running the business of MR dealership. Having heard the learned counsels for the parties, considering the entire fact and circumstances of this case, the state respondent is at leave to use opposition in the use affidavit in opposition within 3 weeks from date. State respondents as well as the private respondents given liberty to use of affidavit in opposition within 3 weeks from date. Reply, if any, by the petitioner within 2 weeks thereafter. Let the matter go out of the list. Parties are at liberty to mention after exchange of affidavits.
gratefully.
Instead of go out of the list, kindly fix a date. A date.
5 weeks. How can
2 weeks, 1 week.
We should end after the vacation.
2 week, 1 week.
Whatever may be, it
Your
will
Lordship,
appear
2
after
weeks is not
vacation.
possible.
After vacation, it will appear.
After vacation, Your Lordship.
If it suits to your lordship,
Huh.
fix it.
Last week, you know, you would be very
Last
busy
week
for
is
that.
not possible, thereafter. I'm not saying the last week of the vacation, your lordship will take up the hearing matter.
Before that, it is not possible.
No, no.
After that,
After that,
any day,
After
November,
vacation, your lordship, anytime
any
after.
day.
first week of November. Let the matter appear in the monthly list of November.
Monthly.
Okay, next.
Grateful, your lordship. Lordship, I appear for the petitioner, my lord. In this matter, my lord, we had challenged the vacancy notification that was issued in 2022 under the 2013 control order, which is under challenge before the Honorable Division Bench, my lord. Now, thereafter, my lord, your lordship will kindly recollect, my lord. I had filed an application, a writ application. Thereafter, I had also filed an application praying for an interim order. An interim order was passed by your lordship. And I have served the application, my lord. And pursuant to your lordship's order, they have also filed a report. Well, I would like to use an exception, my lord, to that report. And the interim order was passed on 14th of May, my lord. And lordship, it was extended till 1 week after vacation. In any event, my lord, I would like to file an exception, and they haven't filed an opposition to my application.
Your lordship, I am filing the affidavit in opposition to their application. Your lordship. Copy served.
I would like to file a reply to this opposition, my lord, because of my personal difficulty, my lord.
Very well. Let the matter go out of the list.
Lordship, let there be an interim order. That interim order which your lordship
Should be extended.
Lordship. আমি জানি
Affidavit in opposition file on behalf of the respondent number 1 to 4 be taken on record. Petitioner is at leave to use reply to the opposition within 3 weekends.
এটা তো এই
Full stop.
petitioner reply.
Let the matter appear in the list 1 week after ensuing puja vacancy. Under the same head. No, under the heading hearing. Full stop. Parties are at leave to exchange their affidavit in the meantime. Full stop. Interim order passed by this court on 14th of May 2025 be further extended till 3rd week of November 2025 or until further order, whichever is earlier.
I'm grateful.
Next.
And for the petitioner, my lord, had directed to file a report by the state authorities, my lord.
May it please your lordship, in this matter, I am appearing for state, my lord. My lord, may I hand up the report, my lord? Affidavit in the form of report, my lord.
May I be favored with a copy of the same
Yeah,
subject?
Yes, you have a copy.
Yes, sure. That's your right. My lord, if your lordship may kindly, may I indicate, my lord, at page 6, my lord, of the report, my lord. My lord, as per the notification, 2013 notification, my lord, the plinth level should be, my lord,
1 feet.
1 feet from the ground level, my lord. My lord, at page number 14, my lord, 12, 13, and 14, my lord, as per the inquiry report, my lord. If your lordship finds, my lord, at page number 12, 13.
Since the height of the godown is road level, so
Is road level, my lord.
is at par with road level.
My lord. And
May I take may I have your lordship's leave to take an exception to this?
Very well. Use exception. So this matter will appear under heading hearing. Please take down a report in the form of affidavit filed by the respondent number 1 be taken on record. Petitioner is at leave to use exception against the report within 3 weeks.
My lord, state respondents.
State respondents করবে respondent number 1 করে state respondent let the matter appear in the list under the heading 1 week after ensuing puja vacation. Parties are directed to exchange their affidavits in the meantime. Next,
Much obliged with your kind leave, my lord.
This matter also, I appear for the petitioner. In this matter also, the
My lord, I am in
Specified.
default. My lord, lordship gives extension of 2 weeks time. In this matter and also the next matter, my lord. In both the matters, I am in default.
report is not ready.
No, my lord. That's it. Kindly, my lord, give us my lord, a fortnight's time at least.
স্বপন কুমার দত্ত, senior advocate, AGP. Six, accommodation for extension of time of 2 weeks to file the report. Let the report be placed on record on 9th of September 2025. Let the matter appear in the list under the same heading on 9th of September. Next,
Same order may be passed, my lord. Same order may be passed in this matter as well. Very sorry. Why you the report? Thirty-eight. No, 38. 38.
similar order, 9th,
Lordship.
9th of September.
Lordship, I'm grateful. Now, we'll continue the orders.
Next,
State, Your Lordship. Your Lordship, the report. I'm serving a copy to my lord.
Yes.
Lordship, vacancy matter, Your Lordship, may be fixed on the same day.
okay, the guidelines. So, those matters I have fixed for hearing.
26th. 26th.
Okay. Report in the form of affidavit filed on behalf of the respondent number 1 to 4 be taken on record. Petitioner is a leave to use exception against the report within a week. Let the matter appear in the list on 26th of August 2025 under the same heading. Next,
Grateful, Your Lordship.
Your Lordship, I'm.
who is for the petitioner?
I'll go ready.
Report.
नाम लिखिए दूसरा नाम दीजिए. I'm appealing for the state, Your Lordship. Lordship has previously been directed us, the state, to serve an affidavit in respect to the report.
Yes.
We have prepared it and filing it today. We have served upon the petitioner also.
Have you served?
Yes, Your Lordship. We have served on 14/7/25.
Affidavit in opposition on behalf of the state respondent number 1 to 6 be taken on record. Copy served. 1 to 6 be taken on record. Next para copy served. None appears on behalf of the petitioner. Next para petitioner has a leave to use reply if any. against the affidavit within 2 weeks hence. Let the matter appear in the list 1 week after vacation. Under the heading hearing.
Deeply appreciated, Your Lordship.
Next.
No, I am for the state responding, my lord. That is my report, my lord.
Report.
Yes. Report in the form of review. I have served the copy already, my lord. Matter relates to 24 control order, my lord.
24 control. Report in the form of affidavit filed on behalf of the respondent number 6 be taken on record. Copy served.
Yes. 11 July I have served.
Okay. None appears on behalf of the petitioner. Petitioner is a leave to use exception against the report in the meantime. Exception in the report within 3 weekends. Let the matter appear in the list under heading hearing 1 week after vacation. 1 week after ensuing puja vacation. Parties are leave to exchange their respective affidavit in the meantime. Next. Not today. Next.
May it please your lordship, in this matter, I am appearing for the state, my lord. My lord, on the last occasion, your lordship directed the state to file a report in the form of an affidavit. So may I hand up, my lord?
Give me the report. Report in the form of affidavit filed by the state respondent be taken on record. Copy served.
My lord, on the if subject to correction on the last occasion also, the petitioner did not appear, so I couldn't serve.
None appears on behalf of the petitioner on call. Consequently, state is a state under inability to serve the copy of the report. State is under inability to serve the report. Considering the situation, let the matter appear in the list again on 25th of August under the same heading. Next.
25th August.
44, my lord, I am praying in not this week only.
Not this week?
Yes, ma'am.
25th, not this week. Next. Next, not today.
Lord, I am for the petitioner. The state was supposed to file an affidavit in opposition.
অস্মিতা দিকে জিজ্ঞেস করো তো 46 কি হয়েছে ফাইলিং হয়ে গেছে
The opposition টা file
আর তুমি আর্গিউ করতে চাও আমি করে দেবো অন বিহাফ অফ ইনস্ট্রাকশনস
না opposition দিলে
রেপোজিশন তো দিবার লোকই কোথায়
তুমি opposition দিলে আমি রিপ্লাই দেবো তারপরে
Miss in a report.
Report, I don't think your lordship, my lord. Lordship, kindly
Next week. Let it be appear in the next week.
May I file a supplementary affidavit today?
Again, supplementary.
My lord, disclosing
Then they
that
have to given a further liberty to file a
my lord,
further
both
report.
can be handled. My lord, I am handing over the copy of the supplementary.
Why
Since-
supplementary?
Because my lord, I have filed some RTI applications saying that the respondent, which is saying that it is his go down, that land doesn't belong to him, and my lord, the person who have who are the owner of the land, they are saying that was never rented or that was never leased to that person. So my lord, I will use that also.
Liberty be given, no. Petitioner be given a liberty to use supplementary affidavit in support of the writ petition. Let the supplementary affidavit be taken on record. Copy served.
Sir.
Taken on record. Next line. Copy served. State respondent had his liberty to use affidavit in opposition against the writ petition as well as the supplementary affidavit filed by the petitioner today. Let the supplementary affidavit, let the report of the state be filed on 10th of September 2025.
8th of
The order was to file an affidavit in opposition. So my lord, I will get a copy to that.
No, then in that case, I will tell you, I'll have to file for both.
My lord, of course, my lord, kindly see the last order. It was affidavit in opposition, not a report.
Yes. Let the affidavit in opposition, not report. Affidavit in opposition.
दोनों का लिखेगा.
List the matter on 10th September 2025 under the same heading.
10 September. The affidavit in opposition.
हाँ देखे नहीं है जी.
10th of September.
Obliged, my lord. Did it.
Next.
Sorry.
Mr. Chatterjee is again appearing, Your Lordship. I don't know whether there was a direction to file something.
Yes. Time for the petitioner.
Please kindly extend my time, Your Lordship. And I do not get to even see the face of Mr. Chatterjee today. I will inquire what has happened. Chatterjee.
By supplementary affidavit, they seek time
Yes,
for.
supplementary affidavit I have. Reena Bibi.
Yes.
I have.
An accommodation is sought for on behalf of the state authority to use to submit a report in the form of affidavit. Let the report be filed within 10th of September 2025. Release the matter on 15th of September. Under the same heading.
और हम लोग उसमें अफेयर तो हम तो करते हैं नियम से मेरे बाकी लोग आते हैं.
Next.
And I'm for the state, my lord. May I file my report, my lord?
Serve the copy?
Yes, yes, already served.
A report in the form of affidavit on behalf of the respondents, state respondents be taken on record. Exception, next para. Exception to the report in the form of affidavit on behalf of the petitioner be also taken on record. So pleadings complete.
He is ready for hearing now.
The matter is otherwise ready for hearing. Okay? When? Next week. Let the matter appear in the list. Day after tomorrow on the same heading. Day after tomorrow. Day after tomorrow. under the same. Next.
केउ तो नहीं petition नहीं.
Report.
My lord, in this matter, there are two different stances. My lord, the unsuccessful candidate previously challenged the issuance of license in favor of this petitioner. In that matter, my lord, the SCFS filed a report saying that the ground of challenge was his family member holds a license, so he is ineligible. But my lord, the two vacancies were initiated at the same time. So the ineligibility in our control order is that at the time of application, none of the family members should hold the license. So my lord, both of them applied at the same time. And at the time of the applications, none of their family members had any license.
Okay.
Then after that, sister-in-law got license. Thereafter, this petitioner got license. So my lord, we filed an affidavit which is annexed in the writ petition, saying that there is no ineligibility. Subsequently, my lord, the next SCFS came and he, after going through the record, he received some complaint and he found that there are two licenses in the same family. He cancelled this petitioner's license. So, my lord, that is our predicament that two different stance.
No, state has to be take one stance.
One stance, my lord. That is why, my lord, we have not prepared the report because, my lord, we need further deliberations. My lord, kindly see the previous affidavit is also annexed, wherein we have stated that he is not ineligible, and then, my lord, we have cancelled his license. So, my lord, we'll take a stance. We'll talk to higher authorities, and my lord, we'll come back before your lordship. So, kindly grant us.
No report is there.
My lord, affidavit is annexed in the our previous matters. Affidavit is annexed in the writ petition only. I'm indicating the page number.
Where is the affidavit?
My lord.
No such affidavit is there. In this writ petition, there is no such affidavit.
Rakesh Pal.
688.
Rakesh Pal.
No report you have filed.
আমরা অ্যাফিডেভিটটা করব অ্যাফিডেভিটটা অ্যানেক্স করেছে তো ও ওটা রাকেশ পাল না ওটা অন্য in this matter my lord the mother-in-law of the dealer has a license, so my lord, he is ineligible.
He is ineligible.
Our reason order says so, my lord, that is at page number 57.
He challenged the reason order.
Reason order is under challenge.
Okay, so where is the report? You have submitted a report in this matter.
But we'll file a report within a week. In this matter, my lord, there is no.
Next week? An
no,
accommodation is sought for on behalf of the state respondent for extension of time to file a report.
Soita Devi Das Ganesh যার
For extension of time.
উপরের গ্রাউন্ডটা
Submit
চলবে না,
report.
এই গ্রাউন্ডটা চলবে।
Let the report be filed within 25th of August 2025. List the matter on 1st of September 2025 under the same heading. Parties are at leave to exchange their affidavit in the meantime.
হ্যাঁ, তো সোজা মামলা আছে এটা। Next. ঠিক আছে। Reason orderটা আমি
Next.
Grateful, my lord.
Lordship, I am for the petitioner lordship. I am paying for not today lordship.
Not today. Next.
These questions, Your Lordship, filing of the reports, I think my learned junior should answer better. They want extension of time. ঠিক আছে? When you answer the court.
Yes, where is the report?
Tell.
It's not ready yet, Your Lordship.
Not ready?
No, Your Lordship.
What are the matters? When the report is not ready?
Maybe the affirming, that's what I learned from her. The affirming part is not there.
An accommodation is sought for on behalf of the state authority for extension of time to file the report. Let the report be filed positively within 10th of September 2025. List the matter on 15th of September under the same heading.
Grateful, Your Lordship.
Next.
My lord, I am for the petition.
Yes.
I'm appearing for the state, Your Lordship.
This is my affidavit of service. Here, the subject matter of challenge is the selection of the private respondent number 8. Because the respondent authority made selection to the respondent number 8 without following the provisions of the Control Order 2013 as well as the vacancy notice. Because the petitioner is the self-help group. And therefore, as per Control Order Clause 20 clearly says that preference should be given to the self-help group.
Petitioners are the self-help group.
Yes, Lord. In support of
What is the
that,
name?
Pushpa Anandadhara Dal. In support of that, I have annexed a certificate issued by the concerned Women Development Officer. That is at page 16.
No, preference should be given to you. That is true. But whether,
apart from that, the godown of the respondent number 8 is situated on the land of government. That is the land of Public Works Department. That I have stated in paragraph.
But no NOC has been obtained, Your Lordship.
paragraph?
Paragraph 13. Paragraph 13. May I read, my lord?
Yes.
Your petition states that the godown of the respondent number 8 is less than the area measurement mentioned in the vacancy notice, and the office oblique baranda adjacent to the said godown is situated on the government land. Therefore, the respondent number 8 is not at all eligible to make an application for fair price shop license, and also is not entitled to get the side license as per vacancy notice as well as per Control Order 2013. Therefore, the selection of the respondent number 8 is liable to be cancelled and or set aside.
Which area? That is the set of the queue.
Shade and queue.
Set and queue.
Yes, madam. Area is Bokshipur. That is vacancy notice I have annexed. That is at page 17.
Oh, whether is there any record that is the government land, record of the government land?
No, this is the difficulty. All difficulty is because government is not providing the record of the government land.
There is a portal, you can have that. There is a portal, government portal.
No, government portal is not functioning regarding government land. Regarding
Refugee Relief Department has maintained the portal.
That's true, but no record is found in respect of government land, which is recorded as Khotiar number 1.
Khotiar number 1 or the property
or
of the
others land belonging
belonging to the government
and that's why
entities.
We are
And neither any NOC has also obtained, Your Lordship. The
NOC of what?
NOC from
government.
From the government department or from anyone else in whose record it is recorded, in whose name.
Petitioner challenged that the Q said of the private respondent is within the government land. That is the only challenge. So you are saying there no objection of the owner.
Yes, Your Lordship.
That is not the question here. Whether the Q is over the government land or not, that is only the question. So you submit a report
Your Lordship.
in the form of affidavit. Please take down. Petitioner challenged the selection of private respondent number 8 for granting license by the granting license of MR dealership by the respondent authority concerned. It is the contention of the petitioner that they are the self-help group who shall give preference for granting license. However, the private respondent was granted license in spite of a fact that the said of proposed shop come go down, SHED said of proposed shop come go down of private respondent is situated over a government land. Planet Council, appearing on behalf of the state authority, submits that license was granted in favor of the
No license has yet been granted.
okay, it submits that
Election only makes.
that the private respondent was selected selected after complying with all necessary formalities according to the Control Order 2013. Having heard the learned counsel for the parties, it appears that the issue cannot be settled without giving reasonable opportunities to the parties to exchange their affidavits. Let the affidavit be exchanged. Let the state authority be directed to submit a report in the form of affidavit within 2 weeks from date. Reply, if any, by the petitioner within 1 week thereafter. List the matter on 2/1/3. 15th of September 2025 under the same heading.
In the meantime, not to take any further steps, my lord, because
Why?
license has not yet been granted. And that's why I'm saying in the not to take any further steps. Because if any license has been granted, that again it is admitted right, that is government land.
Where is the property? Where is the document? Only your submission is there.
I am unable to collect the document because it is not supplying either by the land reforms department or the portal.
No, I have
It
seen
is-
that there are some
This
documents.
is the whole difficulties.
No, that cannot be.
Specific apartment in paragraph 13.
No supporting documents.
The document you have annexed, that is the whether you have annexed any document in respect of the property or the proposed
Respondent
shop
number
come
eight.
go down of the private respondent,
No, Mr.
then how can I ascertain your submission? At least prima facie. No interim order. Come on 15th.
Yes, sir.
Next.
My lord, in this matter on 10th June, my lord was pleased to direct the state to submit a report. Then again 7th July it was extended. I do
Yes.
not know whether they have.
Report is here. There is no default in this case. The Lordship wanted to know the current population of the petitioner attached to this his shop and the total population to be served by the proposed new price shop. Lordship, second page, Lordship will get it. The first para, 5,096 persons are attached.
Yes.
And the proposed new price shop, they will be serving 2,714 persons.
Yes.
So, my lord, no question of losing any business.
My lord, we have to go through this, my lord. My lord, kindly we have one need to time.
Have you got the report? Copy
No.
of the report? You have a copy.
I am handing over. I have just handed over.
Mr. Shopon Kumar Dotto, learned senior counsel, senior advocate, AGP, submits a short report of the government signed by Subdivisional Controller Food and Supply, Gangarampur. Controller within bracket Food and Supply, Gangarampur. Let the report be kept on record. Full stop. Copy served. Full stop.
I have given him a copy right now.
Copy
Sir, I
served.
received it.
Petitioner intends to use exception to the report.
My lord.
Let the exception be filed within a week. List the matter on 8th of September under the same heading. 8th of September 2025 under the same.
Lordship, grateful, my lord.
It's your lordship. My application, your lordship.
I appear on behalf of the state.
The earlier occasion, your lordship was pleased to direct to the state file affidavit.
Your Lordship, the affidavit is.
Affidavit is being filed and subbed upon me on 10th August 2020.
Your Lordship, it has
On
been.
4th August 2025, your lordship. But unfortunately, your lordship, the petitioner is now hospitalized for the surgery of the gallbladder stone, your lordship. Therefore, I'm beseeching for kindly adjourn the matter because I won't be able to take any instruction from the petitioner and she won't be able to.
Come on 15th September with your exception, if any. Okay. 15th.
And for the private respondent, I was supposed to get a copy of this thing.
I shall
but-
serve a copy.
You serve a copy. Report in the form of a report. No.
Your Lordship, affidavit in opposition.
Affidavit in opposition on behalf of the state respondent number 1 to 5 is taken on record.
Number 2.
Copy served upon the petitioner as well as the private respondent. Petitioner intends to use exception, intends to use reply against the said opposition. Let the reply be filed within 2 weeks. Hence, list the matter on 15th of September 2025 under the same heading.
Deeply obliged.
নাম তো থাকবে চিঠি দিতে হবে
Next.
55, my lord, I am for the petition. On last occasion, my lord was pleased to direct to file a supplementary affidavit. This matter relates to selection of flour for conversion of wheat into a atta.
Your Lordship, please.
What is the report?
Yes, Your Lordship.
Report containing supplementary affidavit, everything?
No, Your Lordship.
Then you serve a supplementary affidavit. Have you served it?
No.
You serve a copy. Then you again file a report against the supplementary.
Your Lordship.
Have you got the report?
Yes.
Okay, please take down. Supplementary affidavit filed on behalf of the petitioner be taken on record. Full stop. Next para. A report in the form of affidavit filed on behalf of the state respondents be also taken on record. Full stop. State intends to use report against the supplementary affidavit filed by the petitioner. Use a report in the form of affidavit against supplementary affidavit filed by the petitioner today. Let the report in the form of affidavit be filed by the state within 2 weeks. Within 2 weeks, hence. List the matter on 15th of September. Under the same heading.
I'm for the period
for the state respondents.
I'm praying for not today, my lord. Tomorrow I shall, my lord.
Next week. Not this week. Next.
I'm for the state.
I'm for the petitioners. So only point involved in this matter, your lordship, that the petitioner.
Call the list.
In 57, your lordship, I'm for the petitioners.
Yes.
So only one point involved on this matter, your lordship, that the petitioner claims that the private respondent doesn't have the your lordship the go downs. The private respondent obtained the your lordship the license by showing your lordship one go down where one criminal case pending your lordship, and that was declaredly locked up by the your lordship police because some illegal activities that was being carried out there in the your lordship go down. And police was your lordship in pursuance to the FIR, the police locked the your lordship the go down. So on that go down, the private respondent shown and thereafter obtained the go down your lordship with the license. So that was the point, your lordship. Your lordship was pleased to your lordship give me an opportunity to file a supplementary affidavit pertaining to some documents. But due to some unavoidable circumstances, your lordship, and personal difficulties of the petitioner, she couldn't come to your lordship to affirm the supplementary affidavit. So therefore, Your Lordship, I'm praying for 1 week time, Your Lordship, so that
This is the
you
third
can
time.
come.
Let the matter go out of the list. You collect the document and file supplementary.
Grateful.
Let the matter go out of the list. Petitioner is a leave to
Mention.
Let the matter go out of the list. Petitioner is a leave to mention after preparation of supplementary affidavit.
Grateful, Lordship.
Next.
Grateful. Great.
Item 58, my lord, I beg to appear for the petitioner, my lord. Copy has been served, my lord, sent, my lord, but due to the problem in server, my lord, in some, my lord.
Copy. I'm applying for the state.
Which copy?
Key copy this. Supplementary affidavit.
Affidavit file করবো না? Affidavit service টা?
Supplementary affidavit copy কোথায়?
ওটা তো আসেনি এখনো, আসুক না আগে। My lord, in this matter, my lord.
Yes.
My lord, I am appearing for the petitioner, my lord. What happened, my lord? The selection process, my lord, the petitioner, my lord, being one of the applicant, my lord, participated in the selection process of, my lord, FPS dealer for the, my lord, location, my lord, Borogaon, under police station Chakolia district, Uttar Dinajpur, my lord. The being satisfied, my lord, the authority concerned, my lord, allotted the, my lord, the ID number to the petitioner, my lord. Thereafter, my lord, physical inspection was held, my lord, at the site offered by the petitioner, my lord. Thereafter, my lord, the authority concerned issued the letter for physical hearing, my lord, along with all the documents. The petitioner appeared, my lord, and the authority was, my lord, quite satisfied with the candidature as well as go down and everything, my lord. But what happened, my lord? Suddenly, the petitioner, my lord, on 26th of March 2025, my lord, came to know, my lord, that his candidature has been rejected by the authority, my lord. Prior to that, my lord, the petitioner as well as the private respondent number 8, my lord, they are from the similar village, my lord. So the petitioner noticed that the private respondent is, my lord, frequent to the office of the, my lord, the authority concerned, my lord. So, my lord, the petitioner through his one person, my lord, lodged complaint before the authority, specifically indicating the, my lord, my lord, the errors and not, my lord, the lacuna which, my lord, which is, my lord, in the candidature of the private respondent number 8, my lord. But without, my lord, without entertaining the application of the petitioner, my lord, the authority concerned, my lord, issued the license in favor of the petitioner, my lord. On the same day, my lord, prior to that information that the candidature has been rejected, the petitioner submitted one RTI application before the district controller as well as subdivisional controller, Islampur district, Uttar Dinajpur, my lord, praying, my lord, certain information. The informations includes, my lord, the documents, the, my lord, bank statement, the affidavits submitted by the candidates, my lord, as well as, my lord, the measurement report, all those things, my lord. However, my lord, after filing of this writ petition, the authority concerned, my lord, supplied the reply, my lord, which I, my lord, crave leave to file through this, my lord, supplementary affidavit, my lord. Here, my lord, may I file, my lord, the supplementary affidavit?
Yes, you just submit.
Kindly, my lord, I have indicated various things in the writ petition, my lord, that why the candidature of the petitioner is suitable and why the candidature of the private respondent number is not suitable, my lord. The first reason is that, my lord, in the writ petition, which I have, my lord, agitated, my lord, that the godown of the private respondent number 8 is situated, my lord, 850 meters away from the location, my lord. And, my lord, there is no proper road, my lord. There is 6 feet kacha pathway, my lord, where the godown of the private respondent number 8 is situated, my lord. My first point, my lord. Secondly, my lord, I have agitated in my writ petition that with the application, my lord, the private respondent number 8, my lord, not submitted the, my lord, the affidavit, my lord, which is mandatory, my lord. In the reply, my lord, in reply to my RTI application, the concerned authority, kindly, my lord, may I place the supplementary affidavit?
A copy of supplementary
You have to serve.
I have served to the private respondent.
Why private respondent or the petitioner?
The copy to that. My lord, here and now I'm supplying, my lord. Kindly, may I place only one document? The, my lord, बस खाली इसको प्लेस कर देना फिर आप कर लीजिएगा, ठीक है? Page 8 of my supplementary affidavit, my lord. Annexure P9, my lord. In this reply, my lord, the authority, my lord, supplied the information that, my lord, now I am pressing only the affidavit portion, my lord. That is mentioned in the, my lord, the second last line, my lord, of page 9.
Page
9, page 8, my lord, sorry. Page 8. Second last line. MD Khurshid Alam is private respondent number 8, my lord.
Yes.
MD Khurshid Alam affidavit serial number 1478 dated 22nd August 2024. The Judicial Magistrate First Class, Islampur, Uttar Dinajpur. This information supplied by the authority that the affidavit which is submitted by the private respondent having serial number such and such, my lord. Having this reply, my lord, the petitioner submitted, my lord, application under Right to Information Act before the District Judge, District Uttar Dinajpur, my lord. And now, my lord, may I place the reply, my lord, supplied by the District Court, my lord. That is the last page, my lord. Start from page 26. দিয়ে দেবো তো এখন কি করবেন আপনি দিয়ে দেবো আরে না দিয়ে দেবো আমি বাড়া my lord, may I place the last page which is the reply, my lord, which is relevant to my issue, my lord. This reply was issued by the Judicial Magistrate, my lord, Second Court, Islampur, Uttar Dinajpur, my lord. My lord, under memo number 105 dated 6 June 2025, my lord. Respected sir, with due respect, I am hereby furnishing the information as sought for in the following manner. Point number 1A. There are two judicial magistrates authorized to do affidavits. Judicial Magistrate, Second Court, Islampur, from 1st day of month till 15th day of the month. And Judicial Magistrate, Islampur, from 16th day of the month till the last day of the month. And point number B, my lord, as the date 22nd August 2024 comes between 16th day of the month and the last date of the month, I have not done any affidavit on 22nd of August 2024, and hence there is no serial number 1478 dated 22nd August 2024 in the register of affidavit maintained in my court. And the third point, my lord, point number C, my lord, I have not done any affidavit before me between 15 July 2024 and 25th August 2024 in favor of the person, namely MD Khurshid Alam, son of MD Jaharul Islam of village Borogaon, PS Chakolia, Uttar Dinajpur, West Bengal. So, my lord.
So what is your answer? What is your question?
My lord, my answer is that, my lord, my answer in the RTA, my
Judicial Magistrate Second Court said
my lord,
he has not
issued,
affirmed or issued any affidavit, administered any affidavit on after 15th.
15th.
The affidavit appeared to be after 15th. So it would be passed by the First Class Judicial Magistrate, First Court, JM.
My lord.
JM First Court. Where is the reply from JM First Court?
My lord, again, my lord, may I, my lord, place page 8?
Yes.
Page 8 of my supplementary.
Judicial Magistrate First Class, Islampur.
My lord, page 8, my lord, second last line, my lord, from bottom, my lord. MD Khurshid Alam affidavit serial number 1478 dated 22nd August 2024. The Judicial Magistrate First Class, Islampur, Uttar Dinajpur. Here, my lord, the authority supplied the information that the affidavit which the...
Not that. You read the information.
Lordship.
You read the information. Second Court has said that he was not engaged after 15th. After 15th, there are other judicial magistrates to administer oath.
My lord, may I again read for my own understanding, my lord?
Yes.
There are two judicial magistrates authorized to do affidavit. Judicial Magistrate Second Court, Islampur, from 1st day of month till 15th day of the month. And 22nd August, my lord, falls, my lord, last two weeks, my lord. And the Judicial Magistrate, to Judicial Magistrate to the affidavit, Judicial Magistrate Second Court, Islampur, 1st day of till 15th day of month and Judicial Magistrate Islampur from 2nd day of the month till the last day of the month. As the date 22nd August 2024 comes between 16th day of the month and the last date of the month, I have not done any affidavit on
Yes, 16th to last of month, the second court of Judicial Magistrate Islampur has not administered any oath.
my lord.
There are other judicial magistrates to administer oath on those points.
There are only two. There are only two, my lord. There are only two, first and second, my lord. And now my learned friend will lead me, my lord. Let me, my lord.
If it's perhaps, my lord, it's a very simple reply, my lord. And my lord, from the tenor of the reply, my lord, it would be absolutely clear, my lord, that this affidavit that has been, my lord, affirmed, my lord, has not been done in the proper form as it should be, my lord, or a forged document.
How can you say so?
Yes, my lord, because
your reply says otherwise.
No. Kindly, my lord, the reply says that there are two judicial magistrates, so there are only two, 1 and 2. Now, as the date 22nd August 2024, why 22nd August 2024? Because that is the date on which the affidavit that they have furnished.
The second part of the month.
That is the second part. That is the 22nd is the date of the affidavit that they have furnished.
After 15th, that is 16th.
After 15th, right? So, in the first paragraph, it says that if any affidavit is affirmed after 16th till the last date, then it has to be by the second judicial magistrate.
Not
sorry,
second.
first judicial magistrate.
And the reply given by the second. You take note properly.
This is from second. Yes. First judicial
You have taken another reply.
Yes. Perhaps your lordship is right. Yes. But apart from this, my lord, a candidate is supposed to have, my lord, at least 50,000 rupees.
Financial capabilities.
Financial capability, my lord. That also.
Page 27.
Lordship kindly comes to page 27 of the supplementary, my lord. And all this, my lord, perhaps, my lord, it is a bit, my lord, premature, my lord, to make submission because the affidavits have not come forth, my lord.
Yes. Let them file the affidavit.
Lord, may I point out one thing on this? Lord, kindly come to page 28 of the writ petition for once. The affidavit.
If my learned friend is placing 28, my lord, then 27 is to be read first, my lord.
My lord,
27
27
makes
of
it
the.
amply clear.
No,
But as I said, my lord, since the license has been issued, my lord, and he is already distributed, my lord.
28 of the writ
Therefore, I have
petition,
no
my lord.
reasons, my lord, to press for any interim order as of now, my lord. Lordship can give directions, my lord, for filing of affidavit in the form of report, my lord. And we can come back, my lord, and
Page
agitate our
28 of the writ petition. My lord, kindly come to the last portion. The affidavit is before the first court Islampur Uttar Dinajpur. So it's clearly before
Okay,
the
okay, I understand. You have been selected.
Yes, my lord.
Given license. Status running the business.
Running
this invested Islam.
Very well. Please take down.
First, second, first or second?
Yeah.
By the
May I have a copy? May I have a copy?
You serve a copy.
Lordship, this is the
Let them
report.
come.
Just if it is on affidavit, then I will.
You file an affidavit.
Yes.
Better to file with an affidavit.
Petitioner challenge the selection of private respondent for granting MR dealership license by the respondent authority in terms of vacancy notification dated 13th of May 2024. It is the contention of the petitioner that there are several infirmities in the candidature of the private respondent. Still then, the authority concerned has issued license in favor of the private respondent. Learned counsel appearing on behalf of the state raised strong objection and submits that after complying with all the formalities according to the control order 2013, the private respondent was selected to be the most suitable candidate. For the said vacancy notification. Learned counsel appearing on behalf of the private respondent submits that he is the most suitable candidate and license was granted in his favor. Now he is catering the business. Considering the entire situations and considering the objections placed in objections and merits in the writ petition as well as the supplementary affidavit filed on behalf of the petitioner today, it appears that the issue involved in the writ petition cannot be decided without giving opportunity to the parties to exchange their affidavits. Let a report in the form of affidavit filed by the state within 3 weeks from date. Private respondent is also at leave to use affidavit in opposition within 3 weeks from date. Reply stroke exception, if any, by the petitioner within 2 weeks thereafter. Let the matter appear in the list. In the second week of November 2025. Second week of November 2025. Parties are at leave to exchange their affidavit in the meantime.
Lordship will kindly record, my lord, that the supplementary affidavit has also been served upon the state, my lord.
Supplementary affidavit filed on behalf of the petitioner be served upon the state as well as the private.
No, I already served.
Lordship letter
I have done it.
Serve Lordship. Lordship page number 13, 14.
Sir, Huda, please serve the legible copy.
Lord, I will serve legible copy.
May I,
Yes.
may I, my lord, make a very innocuous request, my lord?
Yes.
When the state, my lord, files the report, my lord, my lord, at least, my lord, the affidavit, my lord, filed by the private respondent be contained in the, my lord, not the other documents, at least the affidavit be contained, my lord.
You have made a challenge. That's why they have to file it. Otherwise,
they have to file it.
They have to file it.
They
You have made a specific challenge there.
Yes, that's it.
Yes. Next.
Legible copy.
59, I am appearing on behalf of the private respondent.
Who is for the petitioner?
For the state.
My lord, this is one of my colleagues' cases. He's not in town, my lord. I'm seeking a day's accommodation, my lord.
Next week.
La-
Monday.
This is the fourth occasion they are praying for
Praying
time.
for time, your lordship.
Is it?
On every occasion, the petitioner is praying.
Very well.
Monday.
My lord.
25th. Next.
My lord, I am for the implementing applicant. Can 1 of 2025, my lord.
Just wait. Let me call the list.
60, my lord, I am for the
60
petitioner.
can-
Pursuant to your lordship's earlier direction, may I file my supplementary affidavit?
Have you served the copy?
I'm serving in here and now.
Let them place the case.
This was a case of compassionate appointment which was not granted in my favor, my lord. One of the primary reasons, according to the impugned order, was that no objection was not given by the legal aids. I had annexed the no objection to my writ petition, but my lord's query was there whether it was placed before them. Now I have given annexed a forwarding letter, which is at page 6 of my supplementary affidavit, which specifically says that this was received by them. The received seal is there. I'll just come to the impugned order first, my lord. That is at page 81A of my writ petition.
Where is the no objection?
The no objection, my lord, no objection is part of my writ petition, my lord. It is at page 35, my lord, of my writ petition.
No objection of legal heirs.
My lord.
Shanto Sarkar and Shanti Sarkar.
My lord,
Kamala
kindly come-
Sarkar.
Kindly come to
In supplementary
Kamala
affidavit,
Sarkar.
page number 6, my lord, kindly see there are 3 no objection certificates. The one which we are objecting, that is not present.
Yes.
The other applicant, Chintamani Sarkar, daughter-in-law.
daughter-in-law is not a legal heir. How can daughter-in-law is a legal heir?
She is
my
a
lord?
legal heir.
Daughter-in-law can the daughter-in-law be a legal heir? It's not a class 1 legal heir.
It is not class
Class
1
two-
legal heir.
class
It is
two-
as
If a class
as
one
per
legal-
section 2M of the control order, which will be considered, not the Succession Act.
family members cannot include a daughter-in-law. How can a daughter?
My lord, NOC from all daughters has not been submitted, my lord.
Daughters. He's a daughter-in-law, not daughter. I'm a daughter. I'm a daughter. I have been divorced. Even the decree of divorce was very much with that of the
Kindly
estate.
see, my lord, the control order first.
Cat 1 of 2025.
This is
your
their
application.
Their application.
My lord,
They are the,
Have you received it?
and I have received a copy of that. They are the daughter-in-law of the deceased. In my humble submission, they are not eligible to even apply.
You have file an objection against the can.
My lord, kindly see pursuant to what the submission is. Section 2, subsection M, clause 4. Son's spouse is a family member.
Yes.
So, my lord, what is falling from my learned friend, my lord, is in my humble submission, my lord, is not correct. So, my lord, if she is within the definition of family member, her no objection is required, which is admittedly absent. Accordingly, my lord, my order, which is impugned, 2M subclause 4, my lord, son's spouse.
Son's spouse.
That is daughter-in-law.
Firstly, the order does not say so. Secondly, my lord, I am the daughter. I am a dependent daughter. Admittedly a dependent daughter. The other legal heirs have admittedly given a no objection.
And it is not
No
admitted
mention
that
in
she
the
was
impugned
dependent. She was married at the time of the death.
Married in the time divorce decree was there. Divorce decree was very much with them.
After the demise, my lord,
divorce
decree.
after demise.
And my lord,
Divorce after demise, but
No, that cannot be hard like that. Let them file the affidavits. So can 1, whether you have any objection in can 1?
But I'll be objecting to can 1.
You will object it.
I'll be objecting to can 1 because according to me they cannot have
my
any
lord,
locus.
my lord, we have rejected the application of both the daughter as well as the daughter-in-law.
There are other writ petitions.
My lord, other writ petitions were filed previously, my lord. Orders were passed.
Orders
were passed, but
Now,
that
kindly see
order-
page number 75. Your lordship's order will be there.
No,
Page
Chintamani
82 of my writ
Sarkar.
petition.
Whether Chintamani Sarkar, whether you have filed any writ petition?
My lord, I have filed the first
Yes.
writ petition before them,
You
my
have
lord.
also filed- No. Whether
It
any
is
writ
also
petition is
in the
pending?
cause list, my lord, 192.
192.
Let two of
Let
them, my
both
lord,
the writ petitions be
be
taken
tagged.
together.
The same common order is impugned.
Yes. Common
My
order
lord, I
is-
humbly pray
Common
to
order is that
tag these
let
two and
the
heard these
petitions
two
be tagged. Why should
at
he
once.
be made a
My lord,
party to my
if it
application?
commences,
Very good. If you want to file any objection against the affidavit objection against the can 1,
My lord, one indulgence, my lord. In their writ petition, my lord, they have quoted my reference twice without quoting my name, my lord.
Very good. Supplementary affidavit file on behalf of the petitioner be taken on record. Full stop. Petitioner, no. Can 1 of 2025 is an application for intending intervener, namely Chintamani Sarkar. Chintamani Sarkar. Full stop. It appears that by impugned common order, the prayer for compassionate appointment of petitioner as well as intending intervener was turned down by the respondent authority. Full stop. The petitioner intends to use affidavit in opposition against can 1 of 2025. Considering entire situation, let can 1 of 2025 be fixed for hearing on Monday, 1st September 2025. Under the same heading, petitioner is leave to use affidavit in opposition. Petitioner is leave to use affidavit in opposition against can 1 of 2025 with the meantime.
Both the CAN and the writ petition has been directed to be heard together, man.
I have not passed any order like that.
I'm sorry.
Let the CAN application be, if the CAN application be allowed, then both the matter can be tied.
Since they have filed two
by
independent
consent
writ
of the parties,
petitions,
on the same day, both can be heard.
since they have filed two writ petitions, my lord, if your lordship
is the
can
number,
finally
item
decide
number?
the issue,
My
192.
lord, my item number is 192, my lord. Under heading to be mentioned 1.
If they don't object to their addition, my lord, because
Yes, that's
all of
why
them are necessary parties.
Yes, my lord. My also humble submission, my lord. Take both the matters simultaneously at once, my lord.
By consent add korbe.
Yes, what you want?
Both may be if subject to my
Unless the
lordship's
writ-
convenience
unless
by
the-
the consent of the parties,
Unless
both
the application
have to be
can one be allowed, that cannot be done. I you know. If
the only problem is that if
Very
I
well, very-
if I
okay,
concede
okay,
to the CAN, they will say that
192.
they have a locus.
192, my lord. 192.
Let writ petition number WPA 7449 of 2025 be placed on record along with the instant writ petition.
Obliged, my lord.
On the urgent date.
Soft copy আছে।
Obliged, my lord.
Great, my lord.
On 92. Next.
Okay. 61, my lord, I am praying for not this week on behalf of the petitioner.
Then come on Monday.
On Monday. Great.
Not this week. Next.
62. 62.
62, I'm for the petition.
I'm for the private respondent.
62.
आपके पास
निकाल लेते हैं
62, I'm for the petitioner, my lord. The allegations, my lord, the petitioners are the APS owner, my lord. They are diligently serving the duty, my lord, more than 3 decades, my lord. The allegations against the private respondent, my lord, who is the MR distributor. My lord, the allegations is a pattern of malpractice, my lord, the harassment and systematic my lord, corruption, my lord. The core allegations against the, my lord, the private respondent, who is the MR distributor, my lord, the substandard supplies of the goods and black marketing. Subsequently, my lord, the doorstep violation of the doorstep delivery. My lord, we have made the complaint to the concerned respondent authority several times. My lord, we have made the complaint, my lord, in the year 2021 surrounding. My lord, till then, my lord, they have not taken any steps. My lord, only lordship will find page 145. Lordship will find 154 of the Director of Food Supplies, my lord, had issued a notice, my lord, 154, lordship. Annex P6, my lord, as per the complaint or revealed from your end regarding the alleged malpractice of the MR distribution Shivaprasad Das under Suti 2 number block, you are requested to appear before this inquiry team formed by the director of the DDDPS and 29/2/2024 at 4 p.m. The office of the since then, my lord, they did not take care any allegations made by the petitioners, and since, my lord,
are you present in the hearing?
My lord, we
are you present there at the time?
Lordship.
So hearing take place.
Let the hearing take place. Let it go on. What is the
premature?
Lordship is almost a year.
He is here for the delay.
Lordship.
The facts are to be taken. These are matter of disputed question of fact.
There are many facts. Since we
Disputed
have
question of
received
facts.
instructions in this matter, there are many facts which need to be gone into in a more meritorious and more conclusive way. That is why maybe it is taking time. Definitely, he has come here for a
There are
delay.
some documents, Lordship. It's a systematic corruptions made by the, my lord, private respondent himself, and, my lord,
Maintainability. Maintainability also.
They are relying on 2001 control order and 2003 control order. The restriction. Relying on the provision of 2001 control order, which has already been repealed, and 2003 control order, entire case has been made up. The flaws according to them violation of those two control orders.
So the distributor also given hearing for the objection like
That is for that has been done.
that has been concluded.
It has been dropped from their document as a superior lordship.
Proceeding concluded. Then
Written submission has been stated. Minutes have been recorded that they have annexed also. Thereafter, proceedings has been dropped.
Malad, we have not received any reason order from the department. Malad, we have made the complaint.
Let's come the matter any other day.
let it appear on Monday.
Lordship.
Okay, come on Monday then.
For your lordship, my lord, I am beseeching your lordship, my lord. There are two vacancy matters. Let this appear as mentioned matter, my lord.
Tomorrow.
Yes, my lord.
Which the item?
I am giving the item number. Yes.
Tomorrow I will take up mention matter first.
My lord, that's why I am saying that let vacancy matters. Let it appear as mentioned matter, my lord.
Item number?
151 and 155.
Appearing in the list today.
Yes.
কালকে দুটো দিয়ে দিবেন তো মেনশন ম্যাটারে
আমি giving this.
ওকে
তিনটে দিয়েছি
So
Shall we speak?
Yes. But I am appealing for the petitioner.
Well, I am for the respondent.
The last
Yes.
occasion, respondent has already concluded their argument. Only certain judgment they were supposed to give.
Well, I am.
बोले दो.
1995, 6 Supreme Court cases, 749, paragraph 2.
1995 6 SCC 749. Para?
Para 12.
12.
At paragraph 12.
पढ़ो. थोड़े सुनो तो. थोड़े सुनो.
প্রশ্ন আপনি আবার কিছু বলবেন? Shall I go through, my lord?
Yes. Paragraph?
Shall I go through paragraph 12, my lord?
Yes, paragraph 12.
My lord. Judicial review, my lord. Judicial review is not an appeal from decisions. The review of the manner in which the decision is made. Power of judicial review is meant to ensure that the individual receives fair treatment and not to ensure that the conclusion which the authority reaches is necessarily correct in the eye of court. When an inquiry is conducted on charges of misconduct by a public servant, the court as tribunal is concerned to determine whether the inquiry was held by a competent officer or whether rules of natural justice are complied with, whether the findings or conclusion are based on some evidence. The authority entrusted with the power to hold inquiry has jurisdiction, power, and authority to reach a finding of fact or conclusion. But that finding must be based on some evidence. Neither the technical rules of evidence act nor the proof of fact or evidence as defined there apply to the disciplinary proceedings. When the authority accepts that evidence and conclusion support therefrom, the disciplinary authority is entitled to hold that the delinquent officer is guilty of charge. The court plus tribunal in its power of judicial review does not act as appellate authority to reappreciate the evidence and to arrive at its own independent findings on the evidence. The court tribunal may interfere where the authority held the proceedings against the delinquent officer is in a manner inconsistent with the rules of natural justice or in violation of statutory rules, prescribing the mode of inquiry or where the conclusion or finding reached by disciplinary authority is based on no evidence. If the conclusion finding is such as no reasonable person should have ever reached, the court / tribunal may interfere with conclusion or the finding and mold the relief so as to make it appropriate to the facts of each case.
Yes.
This is the judgment we would like to make.
2006 SCC online Calcutta 200. Who relied this? State.
216. 2016.
2006.
We have relied upon.
We have relied.
Yes, Sheikh Yasin. On that day, my lord, because of on the last occasion, Mr. Sahara was arguing, my lord, that 2006 was relied upon, that suspension cannot continue for the indefinite period.
Yes, yes.
Only that part.
That's all? Okay, reply.
My lord, reply, kindly give us one. Mr. Sahara is, my lord, engaged in court number 11 today.
Okay. Argument on behalf of the state respondent concluded. Let the matter appear in the list on
tomorrow, day after tomorrow, any day, my lord. We shall take 10 to 15 minutes in same position.
কি আছে আছে 20th 2 p.m.
DPR.
20th 2 p.m.
My lord, you can retain its position, my lord, as item number.
At 2 p.m.
At one, item number one, my lord.
No, item number, there are 2 items. There are already 2 matter fixed. Otherwise, you have to go to September.
My lord.
Let's see whatever.
My lord.
Next.
Item 2, I beg to appear on behalf of the respondent.
This is the second appeal.
Yes, my lord. In the earlier
You
occasion.
are arguing in this matter.
Yes, my lord. My lord, last occasion, my lord, my lord, read, my lord, the judgments of, my lord, both the courts below. My lord, this is a.
Give me the paper book. They file an application for.
They filed an application under
Order
Order
41,
41,
Rule
Rule 27.
27.
Well,
Deed of family settlement is there.
yes.
This is only their argument. The deed of
Well,
family settlement state.
Lord.
That is the entire
Well,
property was given
well,
to other persons.
well.
Then the appellant. Then the respondent.
Lord. Lord, this is a judgment of affirmation, Lord. They have challenged, Lord.
Yes, judgment.
Lord, I'll just give Lord brief facts of the case in nutshell because Lord, I have read Lord both the court's judgment. Lord, I will not repeat Lord once again. Lord, they have Lord filed before your Lordship, Lord, one compilation, Lord.
Yes,
this is the Lord compilation your Lordship has, Lord.
Yes, compilation is there.
Yes. Lord, if your Lordship kindly looks into Lord, the compilation, I'll just Lord give the brief facts of the case, Lord, in nutshell. Lord, initially, Lord, a suit was filed by my client, Lord, against Draupadi Gupta, Lord. Lordship kindly sees, Lord, on twofold ground. One is for subletting, that is the main ground, and Lord, defaulter is the second ground. These are the two, Lord, grounds mainly taken. Now, my lord, if your lordship kindly sees, my lord, the schedule of the plaint, my lord, at page 4 of the compilation, the suit property, my lord, consists of 3 bedrooms, 1 kitchen, 1 veranda, 2 bathrooms, and another veranda in north to south and staircase. This is my lord, the suit property. My lord, at my lord, 52 by B, Girish Mukherjee Road. Now, lordship kindly sees, Lord, so far as Lord, the issues are concerned, Lord, they have taken a point that I am not only the owner, there are other owners to the property.
Where is the appellant?
Lord, probably they have Lord, missed. Lord, I do not know. Lord, they are not appearing.
Mr. Bandyopadhyay was there.
Yes, Mr. Bandyopadhyay and thereafter his junior was there. Yes. Lord. Lord, may I proceed or your lordship will take up on some other day because I will Lord proceed. They are not here again. I have
that
to.
Will be difficult.
Lord, it will be difficult. Lord.
One is there for the appellant.
Sure, I'm for the appellant.
Okay,
I
you
apologize
there?
for joining. Yes, I apologize
Very
for
good. You proceed. You proceed. You proceed. Very good.
Now, my lord, so far as my lord, the notice of my lord, notice to quit is concerned, my lord, it is served. That is an admitted position. I'll take your lordship, my lord, to the admitted position first. My lord, if your lordship kindly comes back, my lord, to the judgment passed by the learned court below. চেষ্টা করছি If your lordship kindly comes to page 131 of the compilation, well, this is the judgment dated 30th of April 1987. Earlier occasions, my lord, I have read the entire judgment. I'll just point out, my lord, the few things, my lord, which are required to be, my lord, taken into consideration. Lordship kindly comes back to 133. The lordship will get, my lord, the issues, my lord, framed. First issue was with regard to, my lord, the ownership. Second is very important, my lord, with regard to transfer of possession, that is subletting. Third is, my lord, whether entitled to decree of ejectment or not, and my lord, the other issues are consequential issues, my lord. I need not bother your lordship. 7 except, my lord, issue number 8, which was taken up first by the learned court below. Issue number 8 was, my lord, whether the legal notice was served validly or not. That, my lord, went in our favor. Now, lordship may kindly see, my lord, issue number 4, my lord, went against us. Issue number 4 was, my lord, whether we are entitled to a decree of, my lord, rupees 4,550 as alleged area of rent. My lord, that was, my lord, against us. My lord, I need not bother. Lordship kindly sees, my lord, issue number 2. My lord, the issue number 2 was with regard to, my lord, subletting.
Yes.
Mr. R.K. Gupta, my lord, was, my lord, in her possession. Your lordship has seen, my lord, the actual, my lord, tenant, the land, my lord, the person concerned, my lord, Draupadi Gupta, was not in possession. This gentleman was found in possession, R.K. Gupta.
Yes.
He was found in, my lord, exclusive possession. Now, my lord, the learned court below, my lord, after, my lord, detailing, my lord, all the evidences, and, my lord, after, my lord, scanning, my lord, all the evidences, has come to the conclusion that, my lord, the tenancy, my lord, initially created in the year 1963. My lord, at that juncture, my lord, Draupadi Gupta was there. Thereafter, my lord, this gentleman, my lord, has shown, my lord, certain documents which proves that all along he was not there. He, my lord, came to the suit property subsequently at a much belated stage. Now, if your lordship kindly sees the documents, my lord, which he has shown, my lord, before the learned court below, my lord, at page 137, my lord, the exhibit series, my lord, have been specifically mentioned, my lord. My lord, about, my lord, third line from the top, the birth certificate, exhibit G series, partnership deed, correspondences, affidavit goes to show that the address of Ramakanta Gupta is that of the suit premises. The earliest of these documents in exhibit I, which relates to the period 1965. So it is a subsequent one. My lord, he, my lord, at best, my lord, gave, my lord, documents in support of his possession from 1965, which, my lord, goes to, my lord, proof that, my lord, he came back, my lord, to this, my lord, came to the suit property at a later stage. He was not at the initial stage. And that is, my lord, the exact finding of the learned court below, my lord, on which, my lord, the judgment was passed. Therefore, there is no documentary evidence to show that R.K. Gupta has been residing in the suit premises since the inception of the tenancy as one of the family members. Now, my lord, the learned judge in the court below, my lord, further observed, my lord, at the bottom of that particular page, my lord, page 137, your lordship kindly takes into account, my lord, about, my lord, 6th line, my lord, from that bottom. Therefore, getting discharge of liability of payment of rent by the wife of DW1 necessarily means that she was the tenant. The defendant, by an affidavit before the rent controller, has claimed and admitted exhibit L that she is the tenant. This is also supported by the evidence of DW2 when he says in his cross-examination that the tenancy of the suit premises is that of defendant Draupadi Gupta. Having regard to both oral and documentary evidence on record, there is no doubt the defendant is the tenant in respect of the suit premises. So, my lord, the landlord-tenant relationship is also established, my lord, from the affidavit, my lord, filed before the learned court below, as well as, my lord, from the evidence of, my lord, DW2. Now, if your lordship kindly sees, my lord, the second paragraph, my lord, of page 138, the DW1 in his cross-examination has admitted that he has purchased a flat at Hastings Park in 1975 and has at once shifted there, and at present he has been living there with his wife, that is the defendant. On the other hand, said R.K. Gupta, who deposed as DW2, in his cross-examination has admitted, I along with my family reside in the suit premises. So, my lord, it shows that, my lord, in 1975, my lord, separate flat was purchased, my lord, at Hastings Park, and, my lord, the DW1 with his wife, that is the defendant, my lord, who never came, my lord, to depose before the learned court below or appellate court below, my lord. They were, my lord, shifted, my lord, to in the year 1975, my lord, to Hastings Park's residence, which was a flat, my lord, purchased subsequently. And, my lord, this R.K. Gupta, who is, my lord, the defendant number 2, my lord, he came to the suit premises and he was in, my lord, exclusive possession. He was enjoying, my lord, the exclusive possession of the suit property. So, my lord, the transfer of, my lord, possession of the suit property is, my lord, proof, my lord, from the corroborating evidence of, my lord, the witnesses. Now, lordship kindly sees thereafter, my lord, the third paragraph of, my lord, 138, my lord, the learned judge of the court below, my lord, came to a specific finding that there was no jointness in the family, my lord. My lord, may I just read? Therefore, from the very evidence of DW1 and DW2, it is clear that the defendant, along with her husband and children, is residing at the Hastings Park flat, and Ramakanta Gupta is residing in the suit premises with his family, including his mother. Even for the sake of argument, it is noticed that the tenancy in respect of the suit premises was taken for the residence of the members of the family of Madanlal Gupta. Yet, the having regarding to the present structure of the family, it cannot be accepted that the jointness of that family still exists. No matter R.K. Gupta had been residing in the suit premises, no matter it is if he got married during the stay in the suit premises, but the matter for consideration before us is whether the jointness of the family still exists. The answer is obviously no. Mere casual, occasional visit by either of them to the suit premises or to the flat Hastings Park does not necessarily mean that the jointness of the family still exists. What appears from the materials on record is that the nucleus of the jointness of the family of M.L. Gupta is no longer in existence. Now, my lord, so far as, my lord, the dependency of, my lord, this particular gentleman, my lord, R.K. Gupta, who subsequently came, that was, my lord, the specific observation made in, my lord, by the learned court below in paragraph, my lord, 2. My lord, may I just read, my lord? Admittedly said R.K. Gupta is in occupation of the suit premises, who is no way dependent upon the defendant. In the facts of clean evidence of defendant's residence at Hastings Park, the postal receipts and the telephone bills, exhibit E and F series, are of no consequence. Since the family of the defendant and R.K. Gupta is no longer a unity, and since the defendant has shifted to her Hastings Park flat, and since said R.K. Gupta is admittedly in occupation of the suit premises, then having regard to the facts and circumstances of the case and careful consideration of both oral and documentary evidence on record, there is no other alternative than to hold that the defendant has shifted to her husband's flat at Hastings Park after transferring possession of the suit premises to R.K. Gupta. So, my lord, the issues, my lord, decided in our favor. Now, my lord, so far as, my lord, the landlord-tenant relationship, my lord, I have already pointed out, my lord, it would appear from Exhibit L. My lord, it is also observed in, my lord, page 141, that, my lord, the landlord-tenancy, my lord, tenant relationship, my lord, is an admitted position, my lord, from the affidavit, my lord, filed by the, my lord, defendant. Now, if your lordship kindly sees, my lord, on the basis of this, my lord, the suit was decreed in our favor. Challenging that, they went up in appeal. The appellate court, almost, same finding. I will not bother your lordship, again reading, the appellate court's judgment. Already, I have, read, the entire one.
Yes.
But, the sum and substance of the judgment is based on, the finding, detailed finding rather, of the learned judge in the court below. If your lordship kindly, sees the appellate court's judgment, from decisions with reasons, page 156 onwards,
Yes.
So far as, the transfer of ownership is concerned, that is, the same finding, came concurrent finding. So far as, the additional accommodation is concerned, that is also a concurrent finding. And, the exhibits have also, taken into consideration by the learned court below. Thereby, upholding, the judgment, passed by the learned court below.
Yes.
Now, in the earlier occasion, I just pointed out before your lordship, by way of, this application, CAN 4760 of 2002. This by way of, this CAN, they wanted to, bring some, new documents, which were not there. Your lordship will, get, that application, for bringing those additional documents at page 174 of the compilation.
Yes.
Now, I'll just, point out, paragraph 2 of it. Sum and substance written in paragraph 2 onwards. If your lordship kindly comes to paragraph 2 for a moment. Jyotindranath Banerjee, since deceased, has 3 sons, namely Birendranath Banerjee, since deceased, Nipendranath Banerjee, since deceased, and Robindranath Banerjee. During the lifetime of Jyotindranath Banerjee, by a registered deed of family settlement dated 10th of December 1969, executed by and between the father and the 3 sons, the said property, which comprised of a ground plus 3-storied building, was partitioned and separately allotted amongst the 4 parties. By the said deed of family settlement, the entire ground floor of the said property, together with the passage lying on the western side of the said property, was allotted exclusively to the said Birendranath Banerjee, since deceased. The entire first floor of the said property was allotted to the said Nipendranath Banerjee, since deceased. However, it was declared that the said Jyotindranath Banerjee, during his lifetime, shall have right to reside in 2 rooms on the first floor of the suit property, and after his demise, the said Nipendranath Banerjee, since deceased, shall be the absolute owner of the entire first floor of the said premises, including the 2 rooms. By the said deed of family settlement, the entire second floor of the suit property was allotted to the said Robindranath Banerjee. By the said deed of family settlement, the said Birendranath Banerjee was allotted 2 rooms on the 3rd floor, together with bathrooms, etc., lying on the southern side of the 3rd floor. And the said Nipendranath Banerjee and Robindranath Banerjee were jointly allotted the 4 rooms flat with 2 bathrooms and the kitchen lying on the northern side of the 3rd floor of the property. The said deed of family settlement was not known to your petitioner till such time as stated hereinafter. The petitioner, as all material times, was the tenant of the entire 2nd floor of the said premises, hereafter referred to as the flat, since the year 1963. The said Nipendranath Banerjee, claiming to be the owner of the said flat, filed an ejectment suit against the petitioner, being title suit number so-and-so, before learned Fort Munsif, Alipur. In the said suit, the petitioner was not aware of the family settlement and the exclusive ownership of Robindranath Banerjee in respect of the said flat. As such, this point was not taken by the petitioner. This fact was fraudulently suppressed from the petitioner by the respondents and their predecessors, and the petitioner has no way of finding out this fact even with due diligence. The suit was decreed by judgment decree dated 30th April 1987 against the petitioner, from which the petitioner filed an appeal, being titled appeal number so-and-so. At this stage, your petitioner was also not well aware of the said registered deed of family settlement. The appeal was dismissed by the judgment on order dated 31st of August 1988. The petitioner thereafter filed the present second appeal on 3rd of February 1989
which was admitted by the order dated 24th of February 1989. A copy whereof is annexed here to marked so and so. By the order dated by the said order, the appeal was directed to be heard on the ground 1 and 5 of the memo of appeal. Then, my lord, 1 and 5 quoted. My lord, 1 is with regard to, my lord, the exclusive possession was surrendered or not, and 2 is, my lord, whether there is a subletting or not. So far as, my lord, the absence of consideration, my lord, passed. My lord, these two, my lord, I'll just try to answer, my lord, by bringing the, my lord, showing those judgments, my lord. Now, my lord, paragraph 7, my lord, even though the tenancy was in the name of petitioner, the tenancy was meant for the user of all family members of the petitioner's father-in-law, late Madanlal Gupta. The petitioner's brother-in-law, Ramakanta Gupta, since deceased, has also been residing jointly with the petitioner and her family members at the said flat since the inception of the tenancy. The son of Ramakanta Gupta is Deepak Gupta, who has also been a resident of the said flat since his birth. Rashid kindly sees, my lord, these are, my lord, contradictory statements. My lord, so far as, my lord, the evidence, my lord, I tried to, my lord, read out, my lord, the entire evidence of DW1 and DW2. Your lordship will find, my lord, contradiction as to who was residing when. Lord, here, my lord, he is saying that they were residing jointly with the petitioner. Whereas, my lord, the evidence, my lord, speaks a different kind of situation. Sometime around June 2000, Rabindranath Banerjee approached Deepak Gupta, a member of the petitioner's family, and made the following representations. By a registered indenture of family settlement dated 10th of December 1969, the entirety of the said premises was partitioned and separately allotted to the different co-owners, and the said Rabindranath Banerjee is the exclusive owner of the said flat. A copy of the deed of settlement was also made available to your petitioner. A copy whereof is annexed here to marked so and so. The petitioner also conducted a title search in the concerned registry, and this fact was thereafter confirmed. Rabindranath Mukherjee was ready and willing to sell the said flat to the petitioner and to or any of her family members. So, my lord, the date of knowledge, they are showing sometime in 2000, which is, my lord, absolutely a vague one. To the extent, my lord, they are saying sometime around June 2000, Rabindranath Banerjee approached Deepak Gupta, member of petitioner's family, and made the following representations, from which, my lord, they came to know. My humble submission before your lordship, my lord, no suitable reasons has been, my lord, shown as to why, my lord, there is a delay of, my lord, so many years, my lord, since 1987. It is impossible, my lord, to believe that they didn't know that there is an existence of family settlement. My lord, assuming, my lord, taking their best case.
Yes.
Now, my lord, even, my lord, this fact was tried to establish through, my lord, this Order 41 Rule 27 application. Your lordship kindly considers, my lord, these factual, my lord, findings. My lord, I will rely on, my lord, those judgments of Honorable Supreme Court that, my lord, in a second appeal, my lord, the scope under Section 100 is very limited. My lord, when there is a concurrent finding, my lord, of the both the courts below, my lord, these factual aspects he's tried to incorporate, my lord, at a later stage, where, my lord, the scope of appreciation of evidence, my lord, is no longer, my lord, left to him. My lord, in the earlier occasion also, my lord, I submitted, my lord, one judgment. My lord, I'll just place, my lord, that judgment, not in an elaborate way, but, my lord, I'll place the, my lord, paragraphs. My lord, where it is specifically held, my lord, even if, my lord, in case of first appeal,
yes,
the scope is different from second appeal. Because even, my lord, in first appellate court can enter into, my lord, the factual scenario. But second appeal, my lord, is only purely based on a substantial question of law, where, my lord, these factual, my lord, things which he tried to, my lord, in fact, not even incorporate, try to show, my lord. My humble submission is that, my lord, they have not till today, they have not, my lord, made any kind of amendment to their written statement. Because their written statement, my lord, states something else. My lord, I'll just show, my lord, the written statement, their amendment, and what they are trying to incorporate. Without, my lord, seeking a formal amendment in their pleading, my lord, they are trying to establish a different case altogether, which is, my lord, not, my humble submission is not legally permissible at this belated stage. Now, my lord, paragraph 9, they tried to rely, my lord, thereafter an agreement was entered into by and between the said Rabindranath Banerjee and Deepak Gupta, by which Deepak Gupta agreed to purchase the said flat from Rabindranath Banerjee on the following terms. The price of the said flat would be 4,75,000. 20,000 would be payable in advance, and balance would be payable at the time of registration. The eviction proceeding against the petitioner would be withdrawn. Formal agreement would be executed, recording the above facts pending registration of the conveyance. In furtherance of the aforesaid agreement was executed by and between Sri Deepak Gupta and Rabindranath Banerjee on December 2000, a copy whereof is annexed. Then, my lord, the story of part payment and all this, my lord, they, my lord, try to incorporate. But, my lord, nowhere in their pleading, my lord, all these facts were incorporated, my lord, by way of seeking a formal amendment. So, my lord, this Order 41 Rule 27 application, my lord, is not maintainable in the eye of law, since, my lord, there is no pleading in support of these documents.
Yes.
Now, my lord, I just request your lordship, my lord, kindly comes back, my lord, once, my lord, their written statement at page 14, my lord, 14. My lord, your lordship will not find anywhere, my lord, in the written statement, my lord, these facts. They, my lord, only, my lord, disputed, my lord, so far as, my lord, the single ownership is concerned, they are saying joint ownership. It's correct, it's a joint ownership. Then, my lord, they, my lord, rather admitted, my lord, the property, my lord, which is, my lord, at a different place at 1/6 Hastings Park. Your lordship will get that admission, my lord, at page 15, my lord, paragraph 3. My lord, the last portion of, my lord, the middle portion of paragraph 3, your lordship will find the lines, my lord. The property number so and so at so and so has been acquired to make up requirements of the family, but acquisition of the said property is an additional house accommodation for purpose of easing congestion in the suit premises. And the defendant states that by that the defendant's possession has not been transferred, or that the documents is not living, the defendant is not living in the suit premises. So, my lord, the transfer of ownership is established. My lord, they were, my lord, having a different, my lord, additional accommodation which they say at, my lord, 1/6 Hastings Park.
Yes.
Now, my lord, lordship kindly sees, my lord, paragraph 16, paragraph 16, paragraph 5 at page 16. My lord, the service of notice is also an admitted position, my lord, that is stated in the written statement. They don't deny, my lord, the notice of eviction, or rather notice to quit, my lord. দাদা ওই এটা সিগনেচারটা দেখিয়েছো না, সিগনেচারটা পেজটা বল। হ্যাঁ, ঠিক আছে। দেখে দিচ্ছি। Now, lordship, my lord, kindly sees, my lord, the signature appearing in the, my lord, written statement at page 8. My lord, it is clearly visible, my lord. Lordship kindly sees, my lord, how she spells Draupadi Gupta. Now, lordship kindly
DROPDI.
yes. Now, lordship kindly sees, my lord, the additional, my lord, evidence, my lord, application, how it is affirmed, my lord, at page 184. My lord, we have serious doubt, my lord, whether this person, my lord, has come up before this honorable court to oath and, my lord, or not. It is, my lord, a totally, my lord, different spelling. Not only that, my lord, a different handwriting altogether.
Yes.
Because, my lord, this particular lady, my lord, who is the defendant, my lord, didn't come before the learned court below or appellate court below for depose. She has filed this application for the first time. She never, my lord, came before the learned court below, my lord, to depose in support of her evidence. Only, my lord, her husband came, and, my lord, this particular gentleman who, my lord, got the possession subsequently, this R.K. Gupta, he came, my lord. My lord, Draupadi Gupta never appeared before the learned court below. Now, my lord, in the earlier occasion, my lord, I, my lord, submitted, my lord, one judgment, my lord. I will not take much time. Lordship kindly sees, my lord, the compilation of judgment, my lord, I have handed over to your lordship, my lord. The index of judgments is, my lord, the first page.
Yes.
Lordship kindly sees, my lord. I, my lord, submitted, my lord, serial number 7, Union of India versus Ibrahim Uddin and another, my lord. Reported at 2012, volume 8, SCC, page 148. এটা তো এটা দিয়েছিলাম। Lordship kindly considers, my lord, page 56 onwards. My lord, I will take your lordship, my lord, only to the relevant paragraphs.
Paragraph 36.
Yes, deeply obliged, my lord. My lord, I need not bother your lordship by reading once again. Lordship kindly sees paragraph 36. My lord, the scope is very limited. And, my lord, the scope is not same in respect to, my lord, first appeal and second appeal. In respect of first appeal, although, my lord, court has some kind of, my lord, my lord,
Court of fact
yes,
finding.
yes, last court of grateful one. So, my lord, I am not bothering your lordship, my lord, reading, my lord, the entire judgment, my lord. All the, my lord, all things, my lord, have been covered in this judgment, my lord. In support of my submission, my lord, another judgment, my lord, I will be relying on, my lord, that is, my lord, serial number 8 at page 92. This is reported at, my lord, 2008, volume 3, SCC, page 120. Basaya Mathai versus Rudra S. Mathai and others. My lord, here, my lord, I will just rely on paragraph 12, if your lordship kindly comes, my lord, for once. Paragraph 11, my lord, states about, my lord, second appeal, my lord, the scope, section 100 scope. My lord, I am not bothering your lordship, my lord, reading, my lord. Yes, paragraph 12, my lord, is the, my lord, paragraph where, my lord, the scope of order 41 rule 27 has been dealt with, my lord. My lord, may I just read, my lord? It is clear that the parties to the lease are not entitled to produce additional evidence as of course or routine, but must satisfy the conditions stated in subclause A and AA. Admittedly, such recourse has not been resorted to either by the party concerned or where those principles adhered to by the High Court or by the High Court. Para 3 of his order shows that the learned judge verified the document produced on his discretion without complying with the mandate as provided under Rule 47 of Order 41. Hence, we are of the view that the finding of the learned judge based on a document produced at the time of argument, divorce Rule 27 referred above, cannot be sustained in the eye of law. In such circumstances, his ultimate conclusion treating the suit property as a family property, partible among the members of the family, is also liable to be set aside. In fact, subclause 2 of Rule 27 mandates that wherever additional evidence is allowed to be produced by the appellate court, it shall record the reasons for its admission. It is needless to mention that the High Court neither followed those conditions for production of additional evidence nor recorded the reason for basing reliance on the same. So, my lord, accordingly, my lord, based on, my lord, those additional, my lord, documents, my lord, the judgment, entire judgment was set aside. And, my lord, your lordship may get, my lord, the scope of, my lord, section 100, my lord, just, my lord, the preceding paragraph, it has been discussed that for factual finding, my lord, the scope, there is no scope, my lord, at all. Post amendment, my lord, the scenario has been totally changed. And, my lord, production of additional evidence has been discussed, my lord, those paragraph A, subparagraph A and AA of, my lord, Rule 27.
Yes.
The due diligence, my lord, they have to show that it could not be, my lord, produced because it was not within their knowledge. Your lordship will not find, my lord, a single line with regard to the explanation as to why, my lord, the delay, my lord, of, my lord, filing this, my lord, additional documents. There is no, my lord, explanation in the application itself. Now, my lord, so far as, my lord, the subtenancy ground,
Yes.
my lord, so far as, my lord, the subtenancy ground is concerned, my lord, I would just request your lordship, my lord, I will just place two judgments. Where from, my lord? My lord, it would appear, my lord, one is, my lord, the Calcutta High Court judgment and another is Supreme Court judgment. Although, my lord, in the Calcutta High Court judgment, my lord, the test, my lord, was twofold. It was subsequently, my lord, altered or modified by the Honorable Supreme Court.
Yes.
My lord, so far as the Calcutta bench is concerned, my lord, Honorable Calcutta High Court was of the view not only exclusive possession, but also, my lord, some kind of passing of consideration is required to be shown. It was, my lord, the earlier view. So far as, my lord, your lordship will find, my lord, ground number 1 and 5. So far as, my lord, the substantial question of law is concerned, the number 5 ground is that, my lord, the passing of consideration. My lord, that was the exact view of the Honorable Calcutta High Court in 1991. If your lordship kindly comes to, my lord, the judgment, my lord, at serial number 2, it is reported at 1991 volume 2 CLJ, page 70. Guiram Pal versus Neolata De. Lord, page 5 to 11. Lord, I'll just place the relevant, Lord, paragraph. The relevant paragraph is at page 10, paragraph 18 and 19. Lord, may I just read, Lord, paragraph 18 and 19, 18 and 19.
Yes.
My lord, 18 says, my lord, it is a settled principle of law that to prove tenancy or subtenancy, two ingredients must be established. Firstly, the tenant or subtenant must have exclusive right of possession or interest in the premises or part of the premises in question. And secondly, that right must be in lieu of payment of some monetary consideration or rent. These are the, my lord, two tests, my lord, which need to be satisfied. So far as, my lord, this honorable court is concerned, my lord, held. Now, my lord, paragraph 19, my lord, subtenancy has not been defined in the West Bengal Premises Tenancy Act, but section 105 of the TP Act defines a sublease as a lease of immovable property as a transfer of right to enjoy such property for a certain time, express of employed or in perpetuity in consideration of a price paid or promised or of money, a share of crops or service or other thing of value to be rendered periodically, or is specified actions to the transferor by the transferee who accepts the transfer of such terms. The question whether there is a subtenancy or license and parting with the possession in particular case must depend upon quality of occupation given to the licensee or the transferee. Mere occupation is not sufficient to infer either subtenancy or parting with possession. The mere fact of letting other persons into possession by the defendant and permitting them to use the premises for their own purposes is not so long the defendant retains the legal possession himself. Parting with possession means legal possession by one in favor of the other by giving him an exclusive possession to the ouster of the grantor. In the instant case, it appears from the evidence on record that so and so, so and so. My lord, I need not, my lord, read the entire one, but my lord, the sum and substance is that exclusive possession should be handed over, my lord, by the grantor, my lord, to the grantee. And my lord, the quality of occupation. Here your lordship has already seen, my lord, all the documents, my lord, have been, my lord, in the name of that R.L. Gupta since 1965. So, my lord, there is an exclusive transfer of possession from, my lord, Draupadi Gupta to R.L. Gupta. And, my lord, this lady, my lord, Draupadi Gupta, my lord, shifted her residence at, my lord, Hastings Park's flat. So, my lord, exclusive transfer of ownership and possession was, my lord, not ownership, exclusive transfer of possession was there. Now, your lordship may kindly have a look to the last portion of paragraph 19, my lord, at page 11. Therefore, if all such tests of subletting are applied to the facts of the instant case, there can be no manner of doubt as found by both the courts that the defendant tenant has actually sublet portions of the suit premises for which he is liable to eviction. It is true that the first appellate court has not discussed in detail in coming to his finding on this point, but as because sufficient materials are there on record, such a conclusion as arrived at by that court is irresistible. This being a concurrent finding, lordship kindly takes note of this. This being a concurrent finding of fact of both the courts below should not ordinarily be interfered with by this court unless such finding is manifestly unjust or it is shown that the courts below misdirected themselves in rendering such finding of fact, which can be assailed as perverse. There is nothing on record to show, nor pointed out as such, by the learned advocate for the appellant showing such findings as manifestly unjust or perverse. The plaintiff respondents are therefore entitled to get a decree for eviction also on this ground. The findings made by this court below are therefore upheld. So, my lord, they have to show, my lord, that the finding of the both the courts below either perverse or unjust, which is not, my lord, my humble submission is they have, my lord, not, my lord, shown, my lord, before your lordship.
Yes.
Now, my lord, from this judgment, my lord, it was held, my lord, in the year 1990. Thereafter, my lord, the Honorable Supreme Court has, my lord, clarified the position in a better way. If your lordship kindly comes to, my lord, serial number 1, 1998, my lord, volume 3, SCC, page 1. It is in between Bharat Sales versus LIC. My lord, page 1 onwards, my lord, is the judgment. I'll just take your lordship, my lord, the relevant paragraphs of the judgment. Lordship kindly comes to, my lord, page 3, paragraph 4 and 5. Lord, may I just read, my lord?
Yes.
Paragraph 4. Subtenancy or subletting comes into existence when the tenant gives up possession of the tenanted accommodation wholly or in part and puts another person in exclusive possession thereof. This arrangement comes about obviously under a mutual agreement or understanding between the tenant and the person to whom the possession is so delivered. In this process, the landlord is kept out of the scene. Rather, the scene is enacted behind the back of the landlord, concealing the overacts and transferring possession clandestinely to a person who is an utter stranger to the landlord, in the sense that the landlord had not let out the premises to that person, nor had he allowed or consented to his entering into possession over the demised property. It is the actual physical and exclusive possession of that person instead of the tenant, which ultimately reveals to the landlord and the tenant to whom the property was let out has put some other person into possession of that property. In such a situation, it would be difficult for the landlord to prove by direct evidence. My lord, this is very important, my lord.
Yes.
The contract or agreement or understanding between the tenant and subtenant. It would also be difficult for the landlord to prove by direct evidence that the person to whom the property has been sublet had paid monetary consideration to the tenant. Payment of rent undoubtedly is an essential element of lease or sublease. It may be paid in cash or in kind, or may have been paid or promised to be paid. It may have been paid in lump sum in advance, covering the period for which the premises is let out or sublet, or it may have been paid or promised to be paid periodically. Since payment of rent or monetary consideration may have been made secretly, the law does not require such payment to be proved by alternative evidence, affirmative evidence, and the court is permitted to draw its own inference upon the facts of the case proved at the trial, including the delivery of exclusive possession, to infer that the premises were sublet. So, my lord, the consideration need not be proved in an affirmative way. The Honorable Supreme Court says, since it is, my lord, done secretly behind the back of the, my lord, landlord, court can draw inference, my lord, including, my lord, the surrender of exclusive possession.
Yes.
Now, my lord, paragraph 5, my lord, is in Rajbir Kaur versus S. Chokesiri and Company, it was held that it was not necessary for the landlord in every case to prove payment of consideration. It was laid down that if exclusive possession was established, it would not be impermissible for the court to draw an inference that the transaction was entered into with monetary consideration in mind. The court further observed that transactions of subletting in the guise of licenses are in their very nature clandestine arrangements between the tenant and the subtenant, and there cannot be furnished direct evidence in every case. It will be noticed that in this case, it was established as a fact that the tenant had parted with a part of the premises in favor of an ice cream vendor who was in exclusive possession of that part of the premises, and therefore the court drew an inference that the transaction must have been entered into for monetary consideration. This decision has since been followed in many cases, as for example UBI versus Cooks and Calvary Properties, upon which as well as we shall presently see, reliance has been placed by the petitioner also. So, my lord, the court is of the opinion that, my lord, the passing of consideration, my lord, need not be proved in an affirmative way because it is passed, my lord, clandestinely.
Yes.
Now, my lord, so far as, my lord, this adverse, my lord, inference is concerned, my lord, I'll place one judgment of, my lord, this honorable court. My lord, it is reported in, my lord, 82 CWN page 684. My lord, in between, my lord, Prabhavati Das versus
Adverse inference.
adverse inference, my lord. 82 CWN page 684. Prabhavati Das versus RR Joneja. My lord, page 12 onwards, my lord, the judgment starts. My lord, I'll be placing, my lord, paragraph 14 and paragraph 11 and 12, my lord, at page 14. My lord, may I just read, my lord, paragraph 11?
Yes.
Subletting like lease is a transfer by the lessee of a right to enjoy the leased property in whole or in part for a certain time or in perpetuity in consideration of a price paid or promised or money, share of crop, service or other thing of value. If a person is given an exclusive right of enjoyment of property or a portion thereof for consideration of anything of value, such right may amount to an interest in property as sublease or subletting. When a person is found to be in possession of property apparently exclusive under a tenant, it may not always be possible for the landlord to establish that such parting of possession amounts to subletting. In such case, when possession by any person under a tenant is not disputed, but here it is also not disputed, it will be for the tenant to establish that in spite of the possession of the premises or portion thereof by such person under him, there is no subletting as contemplated in law, as the relevant facts are within the special knowledge. Failure to produce relevant evidence on this aspect may entitle the court to make an adverse inference against him. So, my lord, the burden shifts, my lord, if it is found that he is, my lord, under a possession of the tenant. So, he has to prove that he is not the subtenant.
Yes.
Now, my lord, paragraph 12. In the case before me, the defendant did not establish by evidence there is no transfer of exclusive possession to his alleged licensee for any consideration of value on the face of the admitted possession of at least a portion of the suit premises by a relation of his. The court accordingly was entitled to draw adverse inference against the defendant, which was not alone on a mistaken notion of onus, which in the context of the admitted position shifted on the defendant as observed in Kumbhan Lakshmana versus so-and-so, AI 1949 Privy Council. However, As the result of the litigation is also equally dependent on the issue of default, it is not necessary to express a final opinion. So, my lord, the burden of proof shifts, my lord, in respect of, my lord, transfer of possession or subletting. Your lordship, my lord, in the evidence, entire evidence, your lordship will not find, my lord, any deposition on the part of, my lord, any, my lord, aspect in the deposition on the part of R.L. Gupta that he was not in, my lord, under, my lord, the Draupadi Gupta. He all along, my lord, stays he is under Draupadi Gupta. Once it is proved, my lord, it is a burden, my lord, cast upon him to disprove that it is not as subtenancy or subletting, which he didn't, my lord, my humble submission.
Yes.
এই জাজমেন্টটা দেখিয়ে দিতে পারা যাবে। Now, my lord, so far as, my lord, the jointness in the family, your lordship has already seen, my lord, the learned trial court has expressed its opinion that there was no jointness in the family. Now, my lord, your lordship kindly comes, my lord, to this judgment, my lord, I'll be relying on. My lord, there is no, my lord, definition, my lord, either in the Premises Tenancy Act, my lord, 1956 or, my lord, in the 1997 Act, my lord, the definition of family is not there. So, my lord, I'll, my lord, just try to, my lord, produce those judgment where, my lord, this honorable court, my lord, as well as, my lord, the Supreme Court has tried to, my lord, explain, my lord, the concept of family, my lord. Your lordship may kindly have a look to ওটাতে আসছি দাদা আগে এটাকে দেখিয়ে দিই তারপর নাজির আহমেদ তো পড়ে আসছে একটু পড়ে আসছে lordship may kindly have a look to, my lord, serial number 5, my lord, it is reported at 1996 volume 1. তোমাকে জাজমেন্টেই পুরো কম্পাইলেশন দিয়ে বানাতে দিলাম। My lord, it is reported at 1996 volume 1 CLT, my lord, page 307, my lord, paragraph 35, my lord, page 35 to 41. It is between Dilip Kumar Dev versus State of West Bengal.
Yes.
Well, I'll just take your lordship, my lord, to the relevant paragraphs. My lord, this particular judgment was related to, my lord, to West Bengal Tenancy Regulation Act 1976. Now, if your lordship kindly comes to, my lord, page 37, paragraph 14 onwards. My lord, may I just read, my lord, paragraph 14? But the question which is patent for examination of the court within the realm of the writ jurisdiction is as to whether the petitioner has or had really more than one flat, either in his own name or in the joint name elsewhere within a reasonable distance. The petitioner, if comes within the fold of section 3 of the Act, the remedy cannot be excavated by him by any means whatever. Thus, in the light of the claim, the definition family should be construed keeping in view the scheme and object of the statute. Family has been defined to include parents and other relations of the tenant who ordinarily reside and dependent on him. So, my lord, two criteria has to be satisfied. My lord, not only relationship, but also, my lord, they should ordinarily reside. And, my lord, the person concerned should be dependent on him. Here, your lordship will not find any kind of dependency of R.L. Gupta.
Yes.
The two essential ingredients coming within the wing of the definition family are ordinarily reside with him and dependent on him. The above noted expressions are not mutually exclusive of each other, but coextensive. The conditions must be satisfied. In default, the definition of family shall remain incomplete and inoperative. It is manifest from the materials on record that the wife of the petitioner has an independent income of her own, and his son is not dependent on her husband, as all of them earn their livelihood by the sweat of their own brows. Then, my lord, paragraph 17, lordship kindly looks into, my lord, Further, when the petitioner, his wife, and their son having independent source of income, the question of dependence is a misnomer. At the most, the wife may come within the first part of the essential requirement of Section 3 of the Act, namely ordinarily reside with him and nothing more. Therefore, the other requirement dependent on him still remains unsatisfied. This is an unnatural silence in the statute as to what course of law will take when one condition is satisfied, keeping the other unfulfilled. This is a big why in the statute, which none of the learned counsel made any attempt to reconcile it. If a logical interpretation is put in, it can be inferred legitimately that a person cannot purchase or acquire more than one flat within a reasonable distance from the other in occupation of his or the members of the family dependent on him. So, my lord, in this particular case also, my lord, the person concerned does not have any kind of, my lord, dependency. He has independent income and business of his own. And he, my lord, was transferred, my lord, to the suit premises, my lord, in the year 1965. Now, my lord, I'll just, in support of my, my lord, contention and definition with regard to family, my lord, I'll rely on, my lord, another judgment of this honorable court, my lord. That is serial number 6, my lord, 1991, volume 1, CLJ, my lord, 392. Himanshu Vikas Dash versus Ramendra Mohan Dotto. My lord, page 42 onwards, your lordship will get, my lord, the judgment. My lord, the relevant paragraph, my lord, I'll just place, my lord. Yes, my lord, the relevant paragraph is paragraph 9 and 10. My lord, at page 48. My lord, may I just read, my lord, paragraph 9, my lord. Under the West Bengal Premises Tenancy Act 1956, the landlord can get an order of eviction if he can satisfy the court that the premises is reasonably required of his own use and occupation, and it is also well settled that the landlord's requirement does not meet requirement only for his personal use, but the requirement of his family members is also to be taken. The word family has not been defined under the Act. The question is whether the landlord had no son can file a suit on the ground of requirement of his married daughters for the purpose of their stay occasionally or permanently with the landlord. It was contended by the learned advocate appearing on behalf of the appellant that the married daughters cannot be considered to be a member of the family of the landlord because after marriage she becomes member of other family. Otherwise, she stays at the family. In this case, the admitted position is that plaintiff landlord had no son and he had only 3 daughters, and he claimed rooms for stay of married daughters at the weekend and during holidays and long vacation. Primal Bala Ray's case, Supra, it was held by the division bench that statute nowhere uses the expression family. The requirement for the purpose of evicting a tenant is for the landlord's own occupation. Time and again, different high courts held that the concept of family must be given a wider meaning, and where it appears that the son-in-law of the landlord lived in a rented house and the married daughter was his only child, it is nothing unnatural or improbable that she might come and stay with her father and grandmother on different occasions, and for that one room would indeed be required. We respectfully agree with the view expressed so and so. Then Lordship kindly considers paragraph 12. In Baldev Sai Sahai versus R.C. Vashin's case, Supreme Court held that when a tenant was lying in a tenanted house with his father, mother, 2 sisters and a brother, and subsequently the tenant shifted permanently to Canada along with his wife and children. While leaving for Canada, the tenant had left his mother and brother in the house. In this connection, it was held that the word family has to be given not a restricted but a wider meaning so as to include not only the head of the family but all members or descendants from the common ancestors who are actually living with the same head. The beneficial provision must be meaningfully construed 90 as to advance the object of the Act. The term family must always be liberally and broadly construed so as to include near relations of the head of the family. In our view, even though the case was decided in connection with family of the tenant, the same principle should apply to family of the landlord stroke owner. On the basis of the principles, Lordship kindly sees paragraph 15.
Yes.
On the basis of the principles laid down in the above case, it is clear that the concept of family of the landlord stroke owner cannot be given a restrictive meaning contrary to the spirit of the act, and the court would introduce the meaning which is contrary to the need of the landlord, and that in case landlord had no son, the daughter and son-in-law must be treated as their son. So, Lordship kindly see, although the concept of family, has been explained in a broader sense, but court has in fact restricted its meaning from Lordship kindly sees paragraph 12 at the cost of repetition. I am again reading only to the extent of to the extent that all the members or descendants from the common ancestor. So, if it is from common ancestor, it can be given a broader meaning. But this particular gentleman is not coming from common ancestor. The Draupadi Gupta is the wife of the original brother of R.L. Gupta. Right? He is not from the common ancestor. Draupadi Gupta, she is the original tenant. Her husband's brother.
Husband of Draupadi Gupta and R.K. Gupta are the brothers.
Yes. So, they are not from common ancestor. Original tenant, if R.K. Gupta, then I could have understood. Here, Draupadi Gupta was the original tenant. সবকটা জাজমেন্টই প্লেস করা হয়েছে খালি এটা ছাড়া না নাজিরটা ছাড়া তাই তো নাজিরটা ছাড়া প্যারাগ্রাফটা একটু বলো প্যারাগ্রাফটা একটু বলো হ্যাঁ
Yes.
Only one judgment I'll place and then I'll close so far as judge paragraph একটু বলো Level system. Now, Lordship may kindly have a look to this judgment at serial number 4. This is reported at 2020 volume 19, ACC page 57. This is in between Nazir Muhammad versus J. Kamala and others. Page 16 to 34 is the judgment. If your Lordship kindly comes to page 16, I'll just place the relevant paragraph. This is just to show the scope of second appeal under section 100. I'll just take your Lordship to paragraph 28 at page 27 what is substantial question of law in fact it is the train setter judgment Lordship kindly see to be substantial may I just read paragraph 28 at page 27. To be substantial, a question of law must be debatable, not previously settled by the law of the land or any binding precedent, and must have a material bearing on the decision of the case and stroke or the rights of the parties before it if answered either way. to be a question of law involved in the case, there must be first a foundation for it laid in the pleadings, and the question should emerge from the suitable findings of fact arrived at by courts of fact, and it must be necessary to decide the question of law for a just and proper decision of the case. So, my lord, so far as, my lord, the subsequent event is concerned, it is not, my lord, based on, my lord, the finding of, my lord, fact, because, my lord, those facts have not been, my lord, amended or, my lord, brought in, my lord, in the written statement. So far as, my lord, ground number 5, my lord, so far as ground number 5 at the stage of admission is concerned, my lord, with regard to passing of consideration, your lordship has seen, my lord, Honorable Supreme Court has said that it is no longer a substantial question of law. Consideration can be, my lord, implied also.
Yes.
Now, lordship kindly see, my lord, paragraph 30 onwards, where no such question of law, nor even a mixed question of law and fact, was urged before the trial court or the first appellate court, as in this case a second appeal cannot be entertained, as held by the court in Pachugopal Borua versus Umesh Chandra Goswami. Whether a question of law is a substantial one, and whether such question is involved in the case or not, would depend on the facts and circumstances of each case. The paramount overall consideration is the need for striking a judicious balance between the indispensable obligation to do justice at all stages and the impelling necessity of avoiding prolongation in the life of any lease. This proposition finds support from Santosh Hajari versus Purushottam Tiwari. Your lordship will find that, my lord, this, my lord, lease is continuing, my lord, since 1987. Today we are in 2025, my lord. In a second appeal, the jurisdiction of the High Court being confined to substantial question of law, a finding of fact is not open to challenge in second appeal. Even if the appreciation of evidence is palpably erroneous and the finding of fact incorrect, as held in Ramachandra Iyer versus Ramalingam Chettiar, an entirely new point raised for the first time before the High Court is not a question involved in the case, unless it goes to the root of the matter. The principles relating to section 100 CPC relevant for this case may be summarized thus. 33.1 thereafter lordship sees an inference of fact from the recitals or contents of a document is a question of fact, but the legal effect of the terms of a document is a question of law. Construction of a document involving the application of any principle of law is also a question of law. Therefore, when there is misconstruction of a document or wrong application of a principle of law in construing a document, it gives rise to a question of law. Lord, here your lordship will not find this case, my lord, in both the courts below judgment. Now, my lord, 33.2, my lord, goes as, my lord, the High Court should be satisfied that the case involves a substantial question of law and not a mere question of law. A question of law having a material bearing on the decision of the case, that is a question, answer to which affects the rights of parties to the suit, will be a substantial question of law. If it is not covered by any specific provision of law or settled legal principle emerging from the binding precedents and involves a debatable legal issue. A substantial question of law will also arise in a contrary situation where the legal position is clear, either on account of express provisions of law or binding precedents, but the court below has decided the matter, either ignoring or acting contrary to such legal principle. In the second type of cases, the substantial question of law arises not because the law is still debatable, but because the decision rendered on a material question violates the settled position of law. Lord, here also, my lord, there is no violation of settled principles of law. Your lordship has seen, my lord. Now, my lord, 33.4. The general rule is that the High Court will not interfere with the concurrent finding of the courts below. My lord, this is very important. But it is not an absolute rule. Some of the well-recognized exceptions are where, 1, the court below have ignored material evidence or acted on no evidence. No, this is not the question that court has ignored evidence or acted on no evidence. 2, the courts have drawn wrong inferences from the proof facts by applying the law erroneously. You know, this is also my humble submission, not coming within this ambit. Or 3, the courts have wrongly cast the burden of proof. A decision based on no evidence does not refer only to cases where there is a total dearth of evidence, but also refers to cases where the evidence taken as a whole is not reasonably capable of supporting the finding. So, my lord, these are the three tests, my lord, where, my lord, the exceptionally court can, my lord, interfere, my lord, under section 100 and, my lord, interfere, my lord, into it. Which my humble submission, my lord, doesn't come within this purview. So, my lord, this is the sum and substance of, my lord, section 100, my lord. I am relying on this judgment, my lord. Just to show, my lord, the scope and ambit of second appeal is very limited, my lord. Now, my lord, I'll be, my lord, handing over to your lordship, my lord, one small written notes of argument, my lord. Whatever, my lord, I have argued, my lord, I have just, my lord, tried to, my lord, summarize, my lord. Lordship kindly sees. My lord, I have prepared, my lord, the list of dates, my lord, when the suit was instituted. It was, my lord, in 25th of November. Then, my lord, 87, my lord, the judgment was delivered. My lord, 88, my lord, the first appellate court, honorable learned first appellate court, my lord, was pleased to, my lord, dispose of the appeal, my lord, in our favor. Then, my lord, the second appeal, my lord, they filed in, my lord, 3rd of February 1989, and it was admitted in, my lord, 24th of February. Now, lordship kindly sees, my lord, the substantial question of law, my lord, I have quoted, my lord, again for your lordship's kind perusal, which my humble submission, my lord, the learned court below has properly dealt with so far as subtenancy is concerned. And, my lord, my humble submission, ground number 5 is not at all, my lord, required, my lord, law to be settled because it is already settled by the Honorable Supreme Court. This is not a, my lord, new, my lord, substantial question of law, my lord. It is not coming within the purview. Now, my lord, the plain case, my lord, I have summarized, my lord, your lordship may go through, my lord, and the prayers, my lord. My lord, the schedule of the premises is, my lord, at second floor. Lordship kindly takes note of, my lord, which I have already tried to indicate, my lord. Now, my lord, the synopsis of the case of the defendant, my lord, made out in the written statement, my lord, I have, my lord, tried to, my lord, summarize, my lord. Then, my lord, lordship may kindly skip over to, my lord, page 5, my lord, clause point number G, my lord. My lord, the evidence, relevant part of the evidence, my lord, I have tried to show, my lord, from the exact, my lord, exhibits and compilation, where from your lordship will get, my lord, how, my lord, the learned judge in the court below has derived its conclusion so far as subtenancy is concerned, and, my lord, so far as delivery of possession is concerned, my lord.
Yes.
My lord, I am not detailing. Your lordship will find, my lord, the entire, my lord, I tried to, my lord, rely on.
Very good. I will look at.
Yes. Now, my lord, lordship, kindly, my lord, one point, my lord, I'll just bring to your lordship's kind, my lord, notice. My lord, so far as 116 of the Evidence Act is concerned, my lord, at page 12, my lord, I have placed before your lordship. My lord, this is a preventive clause rather than embargo, my lord, to the tenant, my lord, challenging or disputing, my lord, landlord's ownership. Now, lordship may kindly skip over to, my lord, 2D of the West Bengal Premises Tenancy Act 1956. My lord, I have, my lord, quoted, my lord, what is the exact meaning of landlord? My lord, it includes any person who for the time being is entitled to receive or but for a special contract would be entitled to receive the rent of any premises, whether or not on his own account.
Yes.
So any person, my lord, who is entitled to receive, my lord, comes within the purview of landlord. He need not be even an owner. Now, lordship kindly sees, my lord, section 13A, my lord, I have quoted, my lord, which establishes, my lord, the unlawful transfer of possession as ground of eviction. My lord, it states as, my lord, notwithstanding anything to the contrary in any other law, no order or decree for the recovery of possession of any premises shall be made by any court in favor of the landlord against a tenant except as one or more of the following grounds. Now, my lord, the ground A is whether the tenant or any person residing in the premises led to the tenant without the previous consent in writing of the landlord transfers, assigns or sublets in whole or any part of the premises held by him. So, my lord, here also, my lord, he transfers, my lord, without, my lord, consent of, my lord, the landlord. So, my lord, he squarely comes, my lord, she squarely comes within the purview of, my lord, this clause A. Now, lordship kindly considers, my lord, section 14, my lord, I have quoted. My lord, this is, my lord, the restriction on subletting. It states, my lord, one is, my lord, after the commencement of the act, no tenant shall, without the previous consent in writing of the landlord, sublet the whole or any part of the premises held by him as a tenant. So, my lord, she sublet, my lord, the whole of the, my lord, premises, not even the part. Now, my lord, I have, my lord, placed, my lord, all the, my lord, analysis and findings and the judgments, my lord, which I have already relied on. My lord, your lordship need not look into, my lord. So far as lordship kindly considers the valuation of the property, my lord, at page 19, my lord, I have tried to highlight. My lord, now it is, my lord, more than 2 crores. And, my lord, the rental amount is, my lord, not less than, my lord, 40,000 per month. And, my lord, the rental amount, so far as, my lord, the tenancy is concerned, my lord, he is enjoying the property at rupees 350, my lord, per month. This is, my lord, at the heart of the city, my lord. Second floor, my lord. Square feet কত? My lord, the carpet area is 2,000 square feet. It is in, my lord, Harish Mukherjee Road. Near Harish Mukherjee. Harish Mukherjee kache na, Girish Mukherjee. Near to, my lord, Harish Mukherjee Road, my lord, Girish Mukherjee Road, my lord, just backside, my lord, I am told. Lord, these are my humble submissions, my lord, all about, my lord.
Yes.
And your lordship kindly sees, my lord, the spelling of, my lord, these two signatures, Draupadi Gupta and Draupadi Gupta, my lord. And she never, my lord, came before the witness box, my lord, to depose. Okay.
Reply.
Next date, Mr. Sagar Bandyopadhyay is appearing, madam. But next date he will.
ये मासे तो नहीं होना तरीके अच्छे तीन तारीख तो पे मेरा argument on behalf of the respondent stroke plaintiff concluded. Let the matter appear in the list on 2nd of September 2025 at 2 p.m. for reply on behalf of the applicant.
Grateful, madam.
Instead of second, may it be on third.
No, third, I have 3 matters. Then it will be appear on 8th or 9th.
8th will be better. Second হবে না। Second আমার
9th?
9th will be no issue.
9th. 9th call.
Grateful, madam. 9th. Deeply obliged, madam. My lord, I have handed over a copy of the written notes of argument.
Sir, receive, madam.
Grateful, madam.
Item number 3, I'm appearing on behalf of this respondent number 6. But Orkodipto Sengupta Learned Advocate is appearing on behalf of respondent number 6. He's not on his legs before another court. I'm praying for short passover.
And your lordship knows that your lordship passed an order initially on 10th of February 2025, holding that the writ petition is maintainable. Challenging the same, they preferred an appeal before the division bench, before the honorable division bench. Appeal has been dismissed. This was adjourned on that ground only.
So matter is ready for hearing.
It's a ready for hearing matter. That's why it's fixed today. It's a hearing matter. Opposition reply has been, I mean, state has admitted by filing the affidavit that without any sanction plan, the construction has been raised by the private respondent. So for his by filing affidavit, they have.
You start then.
Yes, sir.
You take note.
But your lordship has heard this matter already. But kindly see your lordship's order dated 10th of February 2025. This was challenged in the appeal.
Yes. Appeal was whether it was the writ petition is maintainable or not on that form.
That was challenged in the appeal.
Yes.
Appeal has been dismissed on last Thursday.
Where is the order of appellate court?
That has not yet been uploaded. I have checked yesterday only. Let me check once.
Whether the appellate court order is in respect of any merit of this matter or like that.
No, appeal said the appeal has been dismissed.
Any observation regarding merit? So you take out the order first.
Oh, what is it?
So can you start today or appellate order of appellate court?
Only one thing. I'm sorry for the affidavit that was filed by us, the private respondent number 6. That was only primarily the affidavit dealt with point of maintainability.
Yes.
Now your lordship has decided. I'm sorry.
Yes. Just take a breath.
Now your lordship.
No, I want to know whether the order was uploaded or not.
No, yesterday night, I have found that the order of the
longish order,
that has not yet
by today or
that has not yet been
It will
uploaded.
be uploaded first.
Very good.
Otherwise, I have to
As
see
well,
the order.
Very good.
Okay.
And only one thing I was saying.
No.
Next week.
I was subject to what Mr. Bhattacharya says. My lord, because the order has affirmed your lordship's order. So your lordship will now be hearing the writ petition, my lord, on the merits, as well as the issues which has been formulated by your lordship in the earlier judgment. Now, my lord, if your lordship permits us, it's a plea before your lordship to allow us to file a supplementary affidavit in opposition. Incorporating certain additional facts which may be germane for adjudication, because the affidavit that has been used by us was primarily on the ground of maintainability.
No, subject to correction, that is
yes,
not.
primarily
And opposing that.
It has been
since that has been your lordship. I have filed my reply at this. They have not.
Okay, come on next week then.
Very good.
Let the matter appear in the list. On. Let the matter appear in the list on 27th of August.
Very good.
At 2 p.m.
At 2 p.m.
Only instead of 27th, can it be any other? Because 27th, there is some difference on my. Yes. Hey, baje kotha khali. But 26, if it commences to your lordship.
26th?
Yes.
26th, it is not possible. Then
any
it
date
appear on 3rd or 2nd of September.
Very well, we can come on that date.
2nd of September.
Not.
Next.
Well, Mr. Bhattacharya has a habit of dragging me to the Supreme Court every time, my lord. But he doesn't take me.
He is very much habituated with before the Supreme Court.
But whatever I have learned from him, my lord.
Very good.
Another one.
Item number 5.
Fine, bro.
My lord, in this matter,
May I file my affidavit? One, they have filed on affidavit. I'm replying the same supplementary affidavit of petition. I'm replying to the same.
Sorry. Affidavit in reply on behalf of the writ petitioners to
Supplementary affidavit.
to the supplementary affidavit, file affidavit in reply on behalf of the writ petitioners to the supplementary affidavit in opposition, file on behalf of the state respondent number 1 to 3 be taken on record. Come on 15th.
But there is some urgency in this matter. What happened, my lord? Every day, on one hand, the state has withheld to make payment of the additional margin on the account of use of EPOS machine and EOing scale. On the other hand, they are issuing so-cause notices and imposing penalty. Today is the learned advocate to start the argument. We are so far, we are concerned, we are ready. And every day we are facing the problem. And since it is, and the Honorable Division Bench since has passed an order that the REIT is maintainable so far representative capacity, all the dealers are facing the problem all over West Bengal. Every day. The amount of huge penalty.
Yes. What is your submission?
and the learned is on his legs. Kindly keeps it not today.
What is the instruction? Learned Advocate General. When it would be start? We have heard the petitioners already. I have heard the petitioners. I have heard the petitioners.
Advocate General,
Learned Advocate General during argument has placed some affidavit.
And we have filed our supplementary reply.
Reply against the supplementary. Whatever may be. Next week, what is your instruction?
I was instructed to ask for accommodation for the day, but
accommodation for the day only. Not today.
Tomorrow it will be.
Tomorrow it will be. কি বলবো বলো? না থাকবে না, ওটা কেটে দিলে ওটা।
We are facing every day. We are facing.
Let the matter appear in the list tomorrow.
Every day, my client is facing the problem of imposing fine or huge penalty. In one hand, they are withholding the same, and on the other hand, using so-cause notice and penalty.
Okay, 2 p.m. কালকে হবে। Next.
Well, 7, my lord, I am for the petitioner. I am led by yes, I am led by Mr. Devabrata Saharai, my lord.
No, state has concluded argument. Today we are for reply.
Yes. So, my lord.
Come on tomorrow then?
Yes.
Not today. 7 and 8, not today.
At 9, I'm for the petitioner. Your Lordship,
Yes.
we are waiting for some documents. I'm paying for 1 week adjournment.
An accommodation is sought for on behalf of the petitioner. Let the matter appear in the list on 15th of September 2025 at 2 p.m.
September 15th.
At 2 p.m. Next.
My lord, I appear on behalf of the appellant.
We are for
My
the
lord,
respondent.
my lord, in the record also, there is no paper book and LCR. I do not have.
These are the second appeals.
Yes, my lord. My lord, I do.
Second appeals.
Yes, my lord.
Affidavit in opposition of the alleged contempt.
লিখে দে নামটা লিখে দে মানে আমাদের সবাই যারা যারা আছে
Contempt.
You have said that the paper books are ready.
Ready, but it was filed in the department, but I don't have any copy. Probably it was missing from my client's record, my lord. My lord, this is a transfer brief, and my lord,
Paper book আছে? So two second appeals.
Yes, my lord, and
File
one cross appeal.
One court.
Yes, my lord.
আছে department আছে. So in the first second appeal is of 2007.
Lordship.
SAT 1987 of 2007.
And SA.
You are the appellant.
Lordship.
And 2008, you are the appellant.
We are for the respondents.
You are the respondent.
We are
In second appeal 109 of 2008.
in both.
In both you are the
There are
respondent.
two suits, one for partition, another for declaration.
Very good.
One
You
filed
are
by my client,
and
another by
CO court. Who filed the court?
I filed.
My lord.
You filed the court.
Respondent filed the court.
Against which second appeal?
Against my lord, it is analogously hard and common judgment was passed.
That is SAT 1987.
And SA 9 of 2008.
109.
So
SAT
court has to be filed against one appeal. Against which appeal you have filed?
Against my lord, in my suit, because I alone filed the suit. The learned judge only this.
Tell me the number of second appeal.
Lordship, SA 9 এর against আপনি ওটা
9.
ওইটার against court
109.
my lord 109 of 2008 against that court was filed by
Court
my
35.
Planet Friends Club.
Yes.
Client.
So you collect the
My lord,
paper book.
my lord, I'm paying only 2 weeks time, and so that I in that
You have your paper books and everything.
My lord, I have.
You have your paper books. So you have to start fast.
Lordship.
An accommodation is sought for on behalf of the appellant. Let the matter appear in the list on 16th of September 2025 at 2 p.m.
Lordship, grateful.
16th of September 2025 at 2 p.m. Full stop. Appellant is directed to collect the paper book from the department. Full stop. Department is directed to place the paper book along with this record. Paper book.
16 September.
16/9 for the appellant.
My lord, may it be treated as hard in part.
No,
Because earlier
I have not heard.
On the earlier occasion,
I have not heard the merit.
Lordship also heard the matter
in court at the time
No, you cannot place the entire matter upon me.
at the time
Let it be start fast.
Obviously, we will start.
at the time of hearing contempt application, your lordship entered into the merit of the matter.
No, that is not the merit. I have to see the
This is also my
substantial question of law. What are they there? These are the starting of second appeal. How can you say that the contempt application be heard and I entered?
No.
In course of hearing,
No.
some
Let the matter be start first. Otherwise, it cannot be. Call the new motion matter. Who is there?
Lordship, I am appealing to an advocate starting with 7:15
Are you there in this matter?
No, I'm not in this matter, but earlier item number 10 to 13. But I'm in 10. Dityendranath Banerjee was here, Lord. 10.
Item number 10 to 13.
10 to 13, item number 10, specifically 10. Because
Contempt application.
Contempt main matter, Lord, I'm not appearing for main matters. But in the
Contempt application you were.
Contempt disposed of. Contempt application, I appeared.
That was disposed of.
Disposed of, but what happened, Lord, my name is not there. 6th August 2025.
You are appearing on behalf of whom?
State.
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 In the contempt application.
Contempt application.
Ninto.
But I'm sorry, Lord, I have to tell Lordship.
ওই আগের অর্ডারটা করুন আগের অর্ডারটা
এতে জিপি নাম আছে তো
Learned counsel Mr. Sachin appeared on behalf of the state
6/8/2025. 4th April my name was there in the order, but 6th August now
appeared on behalf of the state in contempt application number being number CPAN 612 of 2025.
757 CPN 757 of 2024.
You have said
757 top.
Where is the 757?
No, this is in
item number 10 is 612.
No, 6th August order 757 top. Your Lordship's order. 4th April top. CPN, CPN.
Where is the CPN number? What is the number?
757 of 2024.
Okay, 757 কোথায়?
That was disposed of on 6th August.
Order record দিন তো কি বলছে বুঝতেই পারছি না এটা হয়ে গেছে এটা বলে দাঁড়ান দেখি ভিড় পাবে না গো
ওরা কি নাকি নাকি যখন অর্ডারটা
চুপ করে দাঁড়ানো
বাইরে গিয়ে আমরা দেখি
ওকে কি বললাম বলো
কোনটা আমরা আছি কিন্তু কিছু লিস্ট না ফেরত দিয়ে দিই কিছু মূল ম্যাটারে থাকি না কিছু না
in content CPN number 757 of 2024 which was disposed of on 6th of August 2025. Full stop. Erroneously, the name of learned counsel appearing on behalf of the state is not appearing in the cause title. Let the cause title be corrected accordingly. Regarding the representation of learned counsel appearing on behalf of the state in connection with CPA number 757 of 2024. Office is directed to make the necessary correction in the order dated in the cause title of the order dated 6th of August 2025 accordingly. এটা কারেকশনের জন্য এসেছে সার্ভার হবে এইটার উপরে 602 এর উপর এইটা এই যে এটা 10 এর উপর সার্ভার করবেন তাতেই অর্ডার 10 এর উপর সার্ভার করবেন তাতে 757 এর 6 8 এর অর্ডারটা হবে এটা 10 নম্বর অর্ডার হবে 10 নম্বরে যে অর্ডারটা করেছি
But I'm deeply obliged to your Lordship.
আসবে তার আগে এই অর্ডার Yes,
I'm deeply obliged.
Mr. Saha.
Item number 63, my lord.
63.
I am for the petitioner. There is a direction for filing a report. File a report.
Have you received it?
I have received.
But I have not received. It was in place with me.
Kindly adjourn for a period of 2 in the meantime, I shall file reply.
Not today. Next.
টা কি মমতা রাখা না মমতা রাখা There is also direction for filing affidavit in opposition.
I think the report in form of affidavit in opposition.
Yes.
Yes.
But no copy has yet been served upon me.
I can serve him right now, my lord.
Yes.
I file my opposition.
Reply.
No. Just now,
Yes.
my
just now I
learned
have-
friend served the copy of the opposition to me. I shall file reply.
Please take down affidavit in opposition. Affidavit in opposition on behalf of state respondent numbers 1 to 6 be taken on record. Petitioner is leave to use reply against the affidavit within 2 weeks. Let the matter appear in the list on 15th of September under the same heading.
Petitioner, Your Lordship. On last occasion, Your Lordship was directed to file a report by the state respondents.
Have you received any report?
No, Lordship, not yet.
Mr. Dotto was there for the state. No one is there.
In the morning session, Lordship, Mr. Dotto was here.
Yes.
Lordship, kindly fix the date, Lordship, because it's a very small point, Your Lordship. Lordship would remember that matter that SPO shop has been suspended on account of shortfall of stockage of only 22 quintals. That day, petitioner went for Duare ration camp, and the vehicle which was carrying the food grain could not return to the shop because of the breakdown. The next day, when the vehicle came, stock was all okay because it was being put there. But in the morning session only, there was a inspection at that time, 22 quintal shortage they noticed and they made inventory, and on the basis of that inventory my shop was suspended. I repeatedly requested them to come and make inspection because the stock was okay in the evening only. They came, they made inventory, they noted down, there is annexure, Your Lordship, page 30 and 31, 32. Lordship could see that in the inventory made by their officer, the stock is okay, in satisfactory position. Still, they suspended my shop and they also penalized me of 2,44,000. So on that account, Lordship, we made this application. They never considered my representation.
Day after tomorrow.
Lordship, kindly fix the time.
No time can be fixed.
Lordship, otherwise, Lordship, they will not come and not submit the report, Lordship, because the very short point is there that day only Lordship was satisfied that there was no shortfall and your Lordship has that, and they insisted on filing report.
Today, state supposed to file a report. Because today, state supposed to file a report. None appears on behalf of the state. No report has been placed on record. Considering the situation, let the matter appear in the list
Lordship, kindly
on
fix it.
20th of August 2025 under the heading to be mentioned. State is at liberty to submit a short report.
State is at liberty.
State is at liberty to submit a short report in the meantime, after supplying an advance copy to the learned counsel for the petition.
I'm ready to do that.
Next,
66, I am appearing on behalf of the state, my lord, along with my
Which
junior.
for the petitioner?
My lord, on report,
You are the private respondent.
on
What is the
report,
matter?
I have been selected, I have been appointed, I am running the last 4 months. They filed a resolution challenging my
has come from the concerned authority, my lord.
Petitioner
May I
is
file?
last
Last occasion also.
petitioner is not there.
No, my
Let
lord.
me pass an order. Please take down. None appears on call on behalf of the petitioner. The state respondent as well as the private respondent is represented through learned counsels. Full stop. Next, for learned counsel appearing on behalf of the state is also is also appeared along with a short report of the respondent authority. In the absence of the petitioner, the matter cannot be taken up. Considering the situation, the instant writ petition. Considering the situation, it appears that the petitioner is not interested to proceed further with this matter. Petitioner is not at all interested to proceed further with this matter. Accordingly, the matter be listed day after tomorrow under the heading 2 mentioned for further order. 20th, day after tomorrow.
20th.
Next. Not this week. No.
8 minutes time for the picture.
My lord, I am for the state.
My 8 minutes of time.
Yes, Mr. Shah.
Matter what happened, my lord, the respondent authority issued a vacancy notice for appointment of a fair price shopkeeper. Next, P1.
Yes.
At page 40. I have made an application in response to the same vacancy notice along with supplement documents. That is at page 18. P2.
Yes.
You kindly see, received the application for P or name 1 from Sri Abdul Mannan of Block Barasat, 1 Subdivision Barasat, District North Chobbish Pargana for issue of license of APL generation. The application number is 2 and 3. I have deposited the prescribed fee in the name of the petitioner. That is Abdul Mannan. Page 20.
Yes.
Along with supportive document.
Then what happened?
Thereafter, I will come to straightway page 47. P3.
Yes.
Issued a notice of inquiry in the name of my dead father.
Your dead father?
Yes.
47.
Yes. Name?
Your name is Abdul Mannan.
Yes. I had already shown the receipt copy of the application and prescribed fee, challan of the prescribed fee. But here, notice of inquiry issued in the name of my deceased father, Idris Ali. However, I have participated in the inquiry proceeding.
Again, Idris Ali personal hearing.
Yes.
What happened thereafter? What is the status?
Thereafter, no steps have been taken.
No
steps.
Whether your candidature is rejected?
No, nothing has
not yet. Yes, what is the?
My lord, actually the application was made in the name of his petitioner's deceased father.
Deceased father application?
Yes, my lord.
But you have
and
received
he has
the
also
application.
applied. He has also applied before the my lord মুখ্য পরিদর্শক খাদ্য সরবরাহ that her father's name, the application has been applied in the name of his father, not in his name.
Acknowledgement is saying otherwise. Acknowledgement of the receipt of the
Yes.
My lord, kindly see the acknowledgement at page 18, my lord.
Yes.
My lord, it is written Abdul Mannan, but the font is different, my lord.
What do you mean?
My lord, kindly see, my lord, received.
Manipulated?
Yes, my lord.
No.
Kindly see the words Sri Abdul Mannan and other words
You
also.
see the payment history.
And if and
Abdul Mannan you received the Abdul Mannan, received from Abdul Mannan.
my lord, I have a vacancy photocopy of the vacancy register, which also shows, my lord, that the application was made in the name of Idris Ali, not in the name of Abdul Mannan. And he also made a representation on 13th September 2024 that the application was made in the name of Idris Ali.
Where is the application? Where is the representation?
My lord, I'm also handing over the vacancy register.
Yes, erroneously you have said, erroneously you have made application in the name of
My lord,
Idris Ali.
vacancy register also shows, my lord, that it is made in the name of Idris Ali, not in the name of Abdul Mannan.
But yeah, document showing Abdul Mannan. That is page 20.
No,
You have made
that
an
is, my lord,
application erroneously.
manipulated documents, my lord.
Instruction number kindly.
That is all manipulated instructions, my lord.
Everything is manipulated. Payment be
However, you made a separate application to the authority that your application is on your father's name.
kindly direct my land to serve a copy of the same.
Yes, you serve a copy.
I shall talk.
You serve a copy of this copy.
63 kilo.
Please take down.
No, no.
In. Petitioner applied for license of MR dealer in terms of vacancy notification dated 13th of May 2024 issued by SCFS Barasat. SCFS Subdivision Controller Food and Supply Barasat. It is the contention of the petitioner that after his application received online on 13th of September 2024, he made some payment. 3rd of September. Made some payment of requisite fee on the same day.
He made some payment
of requisite fee on the same date to the government by filing GRIPSE challan. GRIPSE challan. However, the respondent authority has served a notice for inspection of proposed shop-cum godown in the name of her deceased father Idris Ali. Though he has participated in the said inquiry, but again, one notice was served for the name of his deceased father Idris Ali. It is the contention of the petitioner that thereafter no steps was taken by the respondent authority. Learned counsel appearing on behalf of the state respondent submits that the petitioner himself submitted application for FPS license in the name of her and in the name of his deceased father Idris Ali. Subsequently, he came to know about the erroneous filing and submitted one application for correction of the same. To the concerned subdivisional controller on 13th of September 2024. 13th of September 2024. Considering the entire situation, petitioner is directed to take instruction. The respondent authority is directed to serve a copy of the application dated 13th of September 2024 upon learned counsel for the petition. Let the matter appear in the list in the second week of September 2025. Second week of September.
Can I get the copy of that, my lord, instruction, because I have only single copy of that.
Pratidi.
Deeply obliged, my lord.
Next.
Denying, my lord, I am for the petition.
I am for the state. Yes. আগের এভিডেভিটটা নিন আগেরটা লিখে নেবেন এভিডেভিট অফ সার্ভিস ফাইল অন দ্য বিল টেকেন অন টেকন আগেরটা ওপর করে লিখেছেন এভিডেভিট অফ সার্ভিস ফাইল অন বিহাফ অফ দ্য পিটিশনার বি টেকেন অন টেকন Yes. Mr. Saha, what is this?
In this matter, I have challenged the vacancy notice for appointment of FPS clerk on the ground that after promulgation of 2015 control order, that is targeted public distribution system maintenance control order, issued the vacancy notice in the year 2022 by following the control order 2013, which has no existence. And on the same issue, appeal is pending before the Honorable Division Bench.
Not pending, I suppose. Kindly seize the last page.
I have annexed the order.
That has been withdrawn. Kindly see.
169.
Same order is standing. Sorry.
And interim order is at page 170.
That is Setara Begum. Is this Setara Begum?
There is Aruti Bera, Rejaul Mullah, Abdul Rahman, Nobin Chandra Halda.
All MAT 1543 of 2024. That is the same issue.
Same issue.
Page 159, Sitara Begum. So where is the vacancy notification?
That is, I have stated in paragraph 6 and 7, because I have not annexed.
Why not annexed?
It has not been able to collect. The petitioner is unable to collect.
Then you collect it and file it.
Already deleted from the website. That notice. I have mentioned the number of the vacancy notice.
Already deleted. You are the one of the fair price shop owner.
Yes.
Nearby one fair price shop owner.
I have mentioned, stated in paragraph 6 and 7.
So interim order is there. Why you are here again? They would not proceed.
No. Interim order in respect confined only to the appellate.
No, I understand. But where is the impugned vacancy notification?
I have stated in paragraph 6 and 7.
Which?
Vacancy notification. আছে না?
No, no, annex করা নেই।
না, annex করা নেই।
Annex it.
It's impossible to collect the same because deleted from the website of the food and supply.
That means 2022.
Yes.
Now the all the procedure has at least
But
concluded.
no steps have been taken for filling up the vacancy. Has not yet.
Then why you are here?
Has not yet filled up. Only application has been accepted and process is going on. At any moment.
Process is going on. You know the interim order. The license can be issued, but not to dealing, not to. This is the interim order.
And that is, I am paying only that interim order.
No,
But otherwise, they will dealing my ration cards.
Then you have to come with a proper way.
I understand.
2022 notification, and now you are coming in the 2025.
But it is.
No, not that. Not that way. The appeal is gone, and you are sitting tight over your matter. Now filing this appeal, filing this writ petition again. You are protected by the Sitara Begum already. State is not taking any steps.
Kindly record that the state will
No,
not.
I should not record it.
And then.
You have come late. You have come very late.
Late, but the appeal is still pending.
Let
Appeal
it
is
be- let
still
it be
pending.
there.
Appeal is still pending.
Let it be there. I keep it here.
They can file a
application pending.
application for addition of party in that matter also, my lord. Which matter is pending, my lord, in the writ petition.
Without filing a writ petition.
The addition of party, my lord.
No, addition of parties should not be allowed in the appeal.
Leave to
Not in
file
the appeal,
application.
not in the
No,
appeal,
no.
my lord, but in the writ. In the writ petition.
Writ was disposed of. It was appeal in the
yes.
Sitara Begum. No, Mr. Mr. Saha, this is very late.
Kindly direct my learned friend to take.
No.
Take instruction
This is
whether
very-
this vacancy notice is rightly mentioned or not. Because I have mentioned.
Come
on
so
the-
late in the year 2022.
That's true, but.
Now
not-
that's
has
why
not
you have
yet-
not.
Process is going on. At any moment, my ration cards may be dealing. Then entire matter would be infructuous, and that's why I am paying.
There is no
And
whisper that the
Since
process has been
2022,
started.
they are sitting tight. Now you have also sitting
Shows.
tight. Now you have come after 3 years. I cannot entertain. I only keep it pending if you want. Otherwise, I will dispose of it.
And direct my last friend to file affidavits. File
No
affidavits.
No affidavit. Please take down. Petitioner is a MR dealer who catering, ration articles, at Gram Panchayat Dattapukur 2, Mauja Joypul, Dattapukur Roman 2, hyphen the Roman 2, Mauja Joypul, Joypul, under police station Dattapukur, district of North 24 Parganas. He challenged vacancy notification. She challenged vacancy notification dated 14th of 12 2022, which was passed under the provisions of West Bengal Public Distribution System within bracket maintenance and control bracket close order 2013. It is the opinion of the, it is a submission of the petitioner that after promulgation of NFSA 2013 and targeted public distribution system and কি বললাম, after promulgation of NFSA 2013 and public distribution system within bracket control order 2015, the control order 2013 on the basis of which the vacancy notification was issued became redundant. Mr. Saha, learned counsel appearing on behalf of the petitioner, submits that issue involved in the writ petition is pending before the Honorable Division Bench for decision. In MAT 1543 of 2024 and others. Mr. Saha further submits that the Honorable Division Bench has already passed an interim order in the writ petition, in the appeal. He submits that same that identical order may be passed. Identical interim order may be passed in this case. Learned counsel appearing on behalf of the state raised strong objection. It appears that the present petitioner has not annexed the vacancy notification. Moreover, the appeals which were pending before the learned division bench may be of similar merit, but as the petitioner has approached this court in very late, approached this court with inordinate delay, this court find difficult to assess the grievance of the petitioner at this stage. Full stop. If the respondent authority has already started the proceeding for filling up the vacancy, they must have concluded the same as per Control Order 2013. However, at this juncture, the writ petition and prayers thereof appears to me not entertainable. Thus, I find no justification to pass an interim order in this matter. However, the state respondent is at liberty to file affidavit in opposition within 4 weeks from date. Reply, if any, by the petitioner within 2 weeks thereafter. Let the matter go out of the list. Parties are at liberty to mention after exchange of affidavit. Parties are at liberty to mention after exchange of affidavit.
I take the writ petition is pending.
Which writ petition?
And from which the MAT application has been filed.
No, MAT is different.
Yes,
many MAT.
No.
At least
Shudip Mal, I can see what they have annexed in page
Shudip Mal single bench order, my lord was pleased to pass.
Yes,
yes.
I'm
referring to different appeals.
Yes,
on the same merit.
Same merit.
It has to be decided by the division bench.
Shudip Mal is pending.
Yes, next. Not this week. Next.
Lordship, in this matter, I am appealing for the petitioner, Lordship. This is regarding, Lordship, rejection of fair price dealership without assigning any reason. What happened, Lordship? I have applied for, Lordship, fair price dealership. Kindly consider page 15 for Kaliachok 1, Selimpur Gram Panchayat. Kindly consider page 15.
Yes.
Now, Lordship, kindly comes to my application, which is at page 19, Lordship. Thereafter, for inspection, 23rd of September 2024 at 12:45, page 20. Inspection was done. Thereafter, a hearing was called on 27th of December 2024. Now, thereafter, Lordship, nothing was communicated to me, Lordship. On searching the Lordship website, I found that page 23 simply, Lordship, rejected. When I, Lordship, have gathered some knowledge that they are, Lordship, going to hand over the, Lordship, says vacancy to a person who is not belongs to the same area, and the, Lordship, the go down has been Lordship, constructed outside the, Lordship, said block also.
Outside the?
Outside the said block, Selimpur. It's not under the Selimpur block.
What is the document that the go down of the private respondent is? Have you served upon the private respondent?
No, Lordship, at that time of filing, Lordship, that's why, Lordship, I am praying before your Lordship to file a report by the state. Kindly direct them to file a report.
No.
What is the status about the progress of the vacancy?
No, progress of the vacancy. Have you made any representation through the authority?
Yes, I have made representation, Lordship.
And the authority may decide the representation within very short period.
Yes, Lordship, because they are going to, Lordship, declare the vacancy in favor of some person. I have came to know that that person is, Lordship, not belongs to the same block.
Whatever may be, you have not named the person in this writ petition.
Because, Lordship, at the time of filing this writ application, it was only rejected. They did not select any.
Very well. You made a representation. Let the authority be decided.
Page 32.
Page 32 is your representation?
Page 32. It will be better if your Lordship kindly call for a report, because
no.
If the Lordship kindly consider, if some person is going, they are declared the vacancy in favor of some person who is not belongs to the area. Now, if I challenge the against by way of another writ application, by that time they will, Lordship,
in
declare.
the writ petition, you have to be very specific.
Yes, Lordship.
Who is the person they want to appoint, they intend to appoint, what is the discrimination, what are the difficulties.
Kindly consider at the point of filing of this writ application.
Then you do not know anything. What is the decision?
Now, Lordship, I can, Lordship, implement him as a party.
Then make him a party.
Yes, Lordship, I will make
him a party.
Then
serve him.
Yes, I have
otherwise,
to serve.
Otherwise, I can relegate the matter to the authority to decide your representation.
Then, Lordship, kindly call for a report, because it will, Lordship, sort out the, Lordship, litigation. Because I have to file another writ application by challenging the, Lordship. If they are not selecting anyone, then, Lordship, it is.
You cannot straightaway come to the writ court. Rejection is their right. They can reject it as you are not
reject. But, Lordship,
okay.
so far as, Lordship, kindly consider
hearing
was conducted. Hearing was conducted, Lordship, kindly consider.
Hearing they had to conduct. This is the rule.
Page 21.
Now, Lordship, all person has to be heard.
Yes. Now, if they want to reject, Lordship, kindly consider if they want to reject.
If you want the reasons why they rejected, then you I relegate the matter to the subdivision controller. He shall decide. He shall serve all documents to you. Then you can challenge it. No issue. Otherwise,
within a short period, Lordship.
Within
a short period.
Please take down. Petitioner applied for license in terms of license of MR dealership in terms of vacancy notification number, vacancy notification dated 13th of May 2024, issued by SCFS Malda Sodor. Application of the petitioner, full stop. The application of the petitioner was received on 30th of August 2024 online by giving him the application number. Full stop. Proposed shop come go down of the petitioner was inspected by the concerned authority on 23rd of September 2024. Petitioner, next one. Petitioner was called for on a personal interview by the concerned subdivisional controller. Full stop. After he was inquired by the subdivision controller, suddenly in the portal it appears that the application of candidature of the petitioner was rejected without assigning any reason. The petitioner promptly made a representation to the authority on 16th of May 2025. The authority concerned not responded, hence this writ. Having heard the learned counsel for the parties, also considering the nature of grievance as ventilated by the petitioner in the instant writ petition, it appears to me that the authority concerned must have assigned the reason for rejection of the candidature of the petitioner by giving him a affordable opportunity of being heard. Affordable opportunity of being heard. Affordable opportunity of being heard. Under the above observation, the instant writ petition is disposed of, directing the respondent number, directing the subdivisional controller, food and supply, Malda Sodor, being
4 Lordship.
Respondent number
4 Lordship.
4. Respondent number 4 to dispose of the representation of the petitioner dated 16th of May 2025 within bracket appearing as P6 of this writ petition within 4 weeks from the date of receiving of the instant order. Full stop. I make it clear that the concerned respondent number 4 shall dispose of the representation according to law after giving the reasonable opportunity of being heard to the petitioner along with documents, if any. Full stop. The decision of the authorities shall be communicated to the petitioner within 2 weeks thereafter. Full stop. It has been clarified that this court has not entered into the merit of this matter. Concerned subdivisional controller shall dispose of the representation according to the law without being influenced by any observation of this court. Without being influenced by any observation of the court. Next para, since no affidavit have been exchanged, the allegation made in the writ petition shall be deemed to have been not admitted. Disposed of.
The parties are to act on the basis of the server copy, Lordship.
Yes.
Lordship, 150 Lordship, today morning mention Lordship. Item number 1, very short matter Lordship, vacancy declaration notice. Item 150.
What do you want?
Lordship, what similar order your Lordship passed the
reached up to 71.
Tomorrow Lordship mention matter and others matter Lordship. That's to be mentioned.
কি আছে কালকে লিস্ট
72 minutes similar matter
71 I have reached up to 71 today.
72 is like similar matter.
What similar matter?
May I place this minute?
How can you place now without judicial hour?
Tomorrow to be mentioned, Milord.
No. Let me see the list tomorrow. কালকে তুই মেনশন কালকে প্রথমে কি আছে মেনশন প্রথমে কি হবে 10 10:30 কিছু নেই তো সেটা তো মুভ হবে ছাড় আর কি আছে তারপরে কি হবে শুরু হবে কি তবে কালকে রেখেছেন 1922 21 and 22 তারপরে কি ম্যাটার ধরবেন মেনশন ম্যাটার আছে কিছু মেনশন ম্যাটার ধরবেন তো কটা আছে মেনশন ম্যাটার 160 18টা হয়ে যাবে 900 তাই দুটো মেনশন ম্যাটার দিয়ে 72 and 150 mention matter.